For reasons mentioned in the judgment, this civil revision petition is allowed and the impugn order is set aside. The Court of Learned District Judge Kamrup Metro is also directed to all the following three cases, namely Ms. J case number 756/2023, title suit number 258/2020, and title suit number 713/2022, one court for disposal. For reasons mentioned in the order, the prayer for bail of the present petitioner is rejected.
Please, Your Lordship, I'd like to mention item number 21. Senior Counsel AM Boyd out of station.
Okay.
The records before your Lordship are not updated, Lordship. Yes, also to be updated, Lordship, because the last date was fixed on 10/12. What happened on that day and subsequent is not before your Lordship.
10/12.
It was fixed on 10/12 for evidence. That is not before your Lordship.
Okay.
See what happened.
Heard, Mr. What is your name?
MS Hussain.
M.S. Hussain, learned counsel for the petitioner, who prays for an adjournment on the ground that senior counsel for the petitioner, Mr. A.M. Bora, is out of station. Stop. On the other hand, learned Mr. B. Sharma, learned public prosecutor, submits that the case before the trial court was fixed last on 10/12/2025, and there is no report as to what happened on that day. Therefore, let a up-to-date status report of the trial pending before the trial court be called for, so as to reach this court before next date. Let this matter be listed.
Lordship, the petitioner is already behind bars for last 300 days, Lordship.
What is your prayer?
But on the 9th, Lordship, before vacation.
No.
Before the holiday.
Uh-huh.
That is
After vacation,
on 19th, Lordship.
21 January.
19th.
No, 21 January. Up to the status report, along with the deposition of witnesses, if they are examined.
My humble request on the 19th. Lordship.
Okay, 19th.
Deeply obliged.
My lord had asked me to mention the matter.
Okay, we'll take it up at 12. 12. You inform the other side.
Look, Mr. Mishra is there.
I'm online.
Okay, we'll take it up at 12.
My lord.
So in this matter, we have also filed the affidavit regarding service that may be called for.
Okay, affidavit regarding service. All for.
Much obliged.
Obliged. May I please, Lordship. I beg to mention item number 4 to 8, Lordship. Consent taken of the petitioner, sir, Lordship. I am appearing for response number 1 and 2, Lordship.
What is your prayer?
Better may come on Friday, Lordship. 4 to 8.
It is urgent, we have to come up tomorrow, Lordship, if possible. Lordship. This day matter is there, execution date is going to be executed.
Day after tomorrow, Lordship, on Friday.
Yeah, okay. What is your name?
P. Devri, Lordship.
Heard, Mr. B. Devri,
On behalf of Mr. A.C. Sharma, Lordship.
appearing on behalf of Mr. A.C. Sharma, learned counsel for respondent number 1 and 2, who prays for an adjournment on the ground of personal difficulty. Also, Mr. S.K. Poddar, learned counsel for the applicant/appellant, who submits that as the execution case is pending, matter is urgent. However, he concede to the prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed day after tomorrow, 9th of January.
Maybe the Lordship. I'd like to mention item number 14, password for the day, Lordship. Someone is out of it.
Item number,
14, on 4.
you have informed the other side.
Yes, senior is informed the others.
You have informed the other side
Yes.
on. What is your name?
Islam.
Heard, Mr. A. Islam, learned counsel for the petitioner who prays for an adjournment on the ground that conducting counsel for the petitioner is out of session. He submits that he has informed the learned counsel for the respondents who has no objection to his prayer. Hence the prayer is allowed. Let this matter be listed 9th of February.
May I please, your lordship, with the consent from the other side, I beg to mention.
Be louder.
Lordship, with the consent from the other side, I beg to mention item number 11.
Yes.
Lordship, in this case, we need some time to file our objection against the condonation petition. So matter may be taken after vacation.
I'm for the petitioner, lordship.
You have no objection.
So, Lord-
Heard. Miss, what is your name? Heard Miss P. Day. Learned counsel for respondent number
And number 10 to 31, 33 to 34, 36 to 41.
who submits that the respondent needs some time to file a written objection against the prayer for condonation of the delay filed by the petitioner. Also, Mr. B. Deori, learned counsel for the applicant who does not raise any objection. Hence, the prayer is allowed. Let this matter be listed on 9th of February
Last of
in
the-
the month of January, 29 January.
Bail hearing PA item 17.
Yes.
May I please, Lord? The second time application lawsuit, either it was rejected lawsuit only on the grounds of section 37 lawsuit. Now the case has been proceeded to lawsuit to some extent, and already lawsuit 6 witnesses has been examined out of 9 prosecution witnesses.
Yes, what is your case?
The case is that lawsuit
What is the date of arrest?
arrested lawsuit on 1st of July 2024. As on date lawsuit 1 year 6 months lawsuit. 1 year 6 months lawsuit.
1 year, 6 months?
6 months 7 days.
Yes.
Lot. The only grounds is that lawsuit after examining the PW6, it was examined on 26th of August 25. So although lawsuit 2-3 days had gone, lawsuit no prosecution has turned up. That is the only the FSL witnesses is there, forensic officer is there, and the IO is there lawsuit. Other has been examined. And except the lawsuit informant, the other prosecution witness, all the statements are contradictory lawsuit. And they have also not followed the lawsuit due procedure of law while the lawsuit they seized the Alice contraband lodge.
No, they have not followed what?
The procedure lodge. That procedure incorporated in lodge the narcotic drugs and psychotropic substance seizure, storage and sampling and disposal rules to 2022. That is apparent lawsuit from the statement.
Where is your rejection order?
Starting from page
59.
59.
Yes, your main case is regarding prolonged incarceration.
Prolonged incarceration as well as lawsuit apparently from the evidence adduced by the prosecution witnesses lawsuit there is no case against the petitioner except the informant lawsuit. who in the first petition also have alleged that Lordship, that there is some other relation with the informant and the secretary regarding the land grabbing case, the police officer. That is different issue, Lordship. But here the other prosecution witnesses, like 6 witnesses have been examined. Their statement are Lordship quite contradictory Lordship with each other. So apparently, Lordship, I'm not going to meticulously Lordship, just apparently Lordship. So Lordship, my humble submission is that if although Lordship section 37 is there, so apparently if Lordship is satisfied on the grounds and the statement deposed by the Lordship, this prosecution witnesses, so it's very much good case Lordship for this accused petitioner. And also they have violated Lordship from the statement of the PW 5 and 6, it is clear that they have violated the rules Lordship 5 of 2020 rules.
What is 5?
5 is Lordship the duty of the deposit in godowns regarding the seized article Lordship.
Yes, Mr.
Lordship allow me to read, I can read.
Sharma. His main case is prolonged incarceration.
Congratulations, Lordship. In that regard, Lordship will kindly see the charges were framed on 17/12/24.
17?
12/24. And the number of witnesses are 9, total number of witnesses. Last witness, if Lordship kindly goes by the scan copy, was PW 6, who was examined on 26/8/25. And after that, Lordship, the records are not updated. I'm not disbelieving him, but the records are not there, Lordship. So I cannot say whether any more witnesses. have been examined.
Whether they have incriminated him,
Lordship,
except his submission is except the
that-
info.
That can be the basis for conviction in the case of
Aye.
Daniel Singh also. Lordship.
Yes, yes.
Lack of independent witnesses do not make any difference.
And prolonged incarceration.
Prolonged incarceration, Lordship, there's a, I'm sure Lordship has already gone through this judgment. Namdev, in the recent judgment.
What it says.
Here, Lordship will see paragraph number 3. Just to sum up the case, Lordship. The High Court, while granting bail, was held that investigation needs are over as the charge sheet stands filed on so-and-so. It has further held that the trial before the special court is unlikely to take place in the immediate future, and the respondent's continuous availability for smooth conduct of trial has been assured by his elder brother so-and-so. Lordship, paragraph 5. Learned additional solicitor general for the state submits that the High Court has not provided justification for waiver of mandatory condition under the section 37 in support of his condition so-and-so. Lordship, Kasif has been referred. Lordship is well aware of Kasif. I will not take your Lordship to that judgment. Paragraph 7, Lordship will kindly see. Par contra, learned counsel for the respondent accused states that the respondent accused has been granted bail after being in custody for nearly 2 years. So in this case, he was for 2 years, Lordship. He further contends that since the High Court was of the view that it would take a long time for trial to conclude, the respondent accused was granted bail. So this was the observation of the High Court, Lordship, in granting bail. I will not bother your Lordship with these submissions, Lordship. Paragraph number 8, Lordship. The court is of the view that the issue of substance abuse so-and-so, Lordship, I will not again bother with this states the present state of situation in India, Lordship. Paragraph 9 also states about the drug abuse problem in India. Then Lordship will see paragraph number 10. This also takes again the present situation of India, Lordship, regarding drug abuse. Paragraph number 11, Lordship, will kindly come. In the present case, this court finds that though the respondent accused was in custody for 1 year, 4 months, and charges have not been framed, yet the allegations are serious inasmuch as not only is the recovery much in excess of the
1 year, 4 months.
and charges were not even framed. But in the above paragraph, Lordship, written for 2 years. In any case, Lordship, but the respondent accused allegedly got the cavities ingeniously fabricated below the trailer to conceal the contraband. Para 12, prima facie, this court is of the opinion that the respondent accused is involved in drug trafficking in an organized manner. Consequently, no case for dispensing with the mandatory requirement of section 37 of NDPS is made out in the present matter. Moreover, this court is of the view that as the accused has been charged with offence punishable with 10 to 20 years rigorous imprisonment, it cannot be said that the respondent has been incarcerated for an unreasonably long time. This is one of the. And let's say one more has come in the recent time, let's say this is the same line.
How to deal with conflicting judgments of,
So we'll have to see that the trial will not conclude in a reasonable time. That has to be considered by your lordship. Here, lordship has seen out of 9, 6 have already been examined after charges and failing the mark.
no,
of
what
decision.
I have to see, whether trial will not be concluded in reasonable time.
Yes,
Or whether the period of incarceration already undergone by the petitioner.
period of incarceration, that cannot be the only factor in my humble submission, because lordship, the punishment that is entailed is.
No,
lordship-
the earlier judgment of the apex court,
Yes,
some of the judgment which you know,
yes,
has observed that prolonged incarceration overrides
Yes.
the embargo of 37.
yes,
So that has not been
yes.
overturned by any of the apex court's judgment.
In my respectful submission, lordship, there cannot be a mathematical formula, lordship.
Yes, yes,
That this is the period,
yes.
it goes.
Court
from-
has to come to a
Yes.
finding
And
that-
lordship will have to see in my respectful submission, the progress of the trial. And also lordship will have to see whether the case is progressing at a normal pace, which lordship can deduce from the scan records, lordship.
here the trial has halted. Since August, it is not progressing.
Lordship, that I will concede to, because after 26/8, probably no witness have been examined, but lordship, from the charge framing till date, lordship, 6 have been examined from 9. If lordship passes a direction to the court to conclude the trial as soon as possible, that will be justice in my regard, lordship, because there cannot be a mathematical formula that if he has completed 1.5 years, bail has to be granted. That, in my respectful submission, does not absolve him of the rigors of section 37. law.
Heard Mr. J.
But
Kolit.
I may be subject to judgment also. Regarding lordship, the prolonged incarceration and as well as the lordship, here lordship, the first one is the Ankur Chaudhary versus lordship state of Madhya Pradesh. In this case, lordship, what honorable apex court has held in paragraph number 3, 4, 5 and 6. lordship. A short judgment, lordship, but it's very legal judgment. In paragraph number 3, lordship, I'm reading.
Yes,
Lordship. Learned Counsel for a witness submit that the punch witnesses period number 3, 4 have been examined and they have not supported the case of the prosecution. On being applied afresh, the trial court rejected his bail application only on the pretext that the investigating officer may also be a punch witnesses who has not yet been examined. The High Court has also rejected the bail application, affirming those findings by the impugn order. And the counsel appearing on behalf of the respondent state submits that in the fact of this case, investigating officer may be treated as punch witnesses. Therefore, the High Court has rightly rejected its application. Our learned counsel for the parties, we have considered the fact and all attending circumstances, including the period of custody and also the previous orders of where this court, while rejecting the bail, was of the view that after the punch witnesses deposed, the fresh recourse may be taken. Now, on examination of punch witnesses have not been supported the case of this prosecution. On fact, we are not inclined to consider the investigating officer as a punch witness. It is to be observed that the failure to conclude the trial within a reasonable time, resulting in prolonged incarceration militates against the precious fundamental rights granted under Article 21 of the Constitution of India, and as such, conditional liberty overriding the statutory embargo created under Section 31B of the NDPS Act may in such circumstances be considered. In view of the above, we are inclined to allow this bail application and direct to enlarge the petitioner on bail on furnishing a suitable bail bond and sureties and such other items and conditions as may be deemed fit by the Honorable Trial Court. So in this case, lordship, also, in my case also, lordship, all punch witnesses, that is the seizure witnesses, lordship, they have not supported the case at all, lordship. They are only the prima facie, lordship. I'm not going to meticulous, lordship. Prima facie, they have stated that they were called to the police station and taken their signature in some papers. First thing. Second thing is that, lordship, regarding the embargo incorporated under section 37, that is not lordship absolute bar lordship. This honorable court has a discretion to consider on the facts of the case lordship. Here in the case of lordship Mahmood Muslim, yes, I'm in the second judgment lordship. Mahmood Muslim alias Hussain versus State and NCT Delhi in paragraph number 1819. What the apex court has said regarding the embargo incorporated in section 37. Reading the paragraph number 18.
Okay,
The conditions which court have to be cognizant of are that there are reasonable grounds for believing that the accused is not guilty of such offences and that he is not likely to commit any offence while on bail. What is mean not guilty when all evidence is not before the court? It can only be prima facie determination. That places the court's discretion within a very narrow margin given the mandate of the general law on the basis of section 436, 37 and 439 of CRPC, which classify offences based on their gravity, instruct their certain serious crimes have to be dealt with differently while considering the bail application. The additional conditions that the court should be satisfied that the accused who is in law presumed to be innocent is not guilty has to be interpreted reasonably. Further, the classification of offence under Special Act, which apply over and above the ordinary bail conditions, requires to be assessed by courts, requires that the courts record its satisfaction that the accused might not be guilty of the offence and that upon release, they are not likely to commit any offences. These two conditions have to the effect of overriding other conditions. In cases where bail is sought, the court assess the materials on record and assess the nature of the offence, likelihood of the accused cooperating with the investigation, not fleeing from the justice. Even in serious offences like murder, kidnapping, rape, etc. On the other hand, the court in this case under such Special Act have to address itself principally on two facts, likely guilt of the accused and the likelihood of them not committing any offence upon release. This court has generally upheld such conditions on the grounds that liberty of such citizens have to in the cases when accused of offence enacted under the special law be balanced against the public interest. A plain and literal interpretation of the condition under section 37, the court should be satisfied that the accused is not guilty and would not commit any offence, would effectively exclude the grant of bail altogether, resulting in punitive detention and unsanctioned preventive detention as well. Therefore, the only manner in which such special condition as enacted under section 37 can be considered within constitutional parameters is where the court is reasonably satisfied on a prima facie look at the materials on record whenever the bail application is made that the accused is not guilty. Any other interpretation would result in a complete denial of the bail to a person accused of such offence as those enacted under section 37 of the Act. The standard to be considered therefore is one where the court would look at the material in a broad manner and reasonably see whether the accused's guilt may be proved. The judgment of this court has therefore emphasized that the satisfaction which the courts are expected to record, that is that the accused may not be guilty, is the only prima facie based on reasonable reading which doesn't call for the meticulous examination of the materials collected during investigation. Grant of bail on ground of undue delay in trial cannot be said to be fitted by section 37 of the Act, given imperative of section 436A, which is also applicable in offence under the NDPS Act 2. So in this case also, lordship, having regard these factors, this court is of the opinion that the facts of the case, the appellant deserves to be enlarged on bail. So only, lordship, the section 37 is there, it doesn't mean that this accused, any person is not entitled for bail, lordship, during investigation or trial. Here only the condition incorporated in section 37 has to be, lordship, gone through. I have mentioned the section 37 in the petition also, lordship. Two conditions are there. First is the lordship, there should be an opportunity for the public prosecutor to raise their objection, and second is the lordship, the prima facie satisfaction of this court. Here, lordship, I have annexed the evidence adduced by the lordship prosecution witnesses, and I'm not lordship willing to lordship go meticulously. So somebody submitting to lordship go prima facie, lordship, of PW 1, 2 and lordship 5, 6. 1 to 2 line of lordship give It's a complete picture of the case, Lordship. It was completely making case, Lordship, because this investigating officer, the informant who has the Lordship, otherwise relation with this accused petitioner.
Okay, this you have submitted.
Sorry.
You need not to repeat.
So, Lordship, that is why I'm submitting, Lordship. This is a very good case to analyze this petitioner on bail, Lordship, because the primary facie, Lordship, will see from the evidence collected by the during trial, Lordship. There is no case at all.
Heard Mr. J. Kolita, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional for the prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Noor Hussain Sheikh, who has been detained behind the bars since 1/7/2024, within bracket, for last 1 year, 6 months, and how many days?
6 months, Lordship, and as on the 7 days, Lordship.
7 days, in connection with Golokganj PS case number 157/2024, corresponding to corresponding to special case number 572/2024 under section 22C of NDPS Act, 1985, which is presently pending before the Court of Learned Special Judge Dhubri. The gist of accusation in this case is Code Para 3 from page 60. Stop. Learned counsel for the petitioner has submitted that the petitioner is approaching this court seeking bail for the second time. Stop. He submits that his earlier application for bail was rejected by this court on 23/7/2025 in bail application number 2108/2025. Stop. Learned counsel for the petitioner has submitted that the petitioner is seeking bail this time mainly on the ground that he has been detained behind the bars for more than 1 year, 6 months, and trial has not yet concluded. So he submits that due to his prolonged incarceration, the fundamental rights guaranteed to him under Article 21 of the Constitution of India has been infringed, and as a result, it has overridden the embargo of Section 37 of the NDPS Act. He further submits that though till date, out of 9 prosecution witnesses, 6 prosecution witnesses have been examined, however, except the informant who has been examined as PW3, nobody has deposed anything incriminating against the present petitioner in this case. PW4, anything incriminating against the petitioner in this case. He further submits that the last prosecution witness to be examined was PW6, who was examined on 26/8/2025, and since that date, the trial has not progressed. He submits that under the aforesaid circumstances, the prolonged incarceration of the petitioner has outweighed the embargo of Section 37 of the NDPS Act. Stop. In support of his submission, learned counsel for the petitioner has cited following rulings of the Apex Court. Number 1, Ankur Chaudhary versus State of Madhya Pradesh, reported in 2024 Supreme (SC) 906 And number 2, Muhammad Muslim alias Hussain versus State NCT of Delhi, reported in 2023, 18 SCC 166. On the other hand, learned additional public prosecutor Mr. B. Sharma has vehemently opposed the grant of bail to the petitioner on the ground that the contraband recovered from the possession of the present petitioner in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act is applicable in this case. He further submits that mere prolonged incarceration would not entitle the petitioner to get bail in a case involving offense regarding possession of prohibited drugs under NDPS Act. He further submits that the trial of this case has progressed well, and already 6 out of 9 listed prosecution witnesses have been examined. He submits that only 3 witnesses are remaining to be examined, and there is unlikelihood that the trial would be prolonged, as only few witnesses are there to be examined. He submits that the informant has, while deposing as PW4, has given categorical implicating statement against the present petitioner regarding his complicity in the alleged offense. And hence, he submits that it is not a case where there is no evidence against the present petitioner. He further submits that in an offense involving drug trafficking, the dispensing of mandatory requirement of Section 37 of the NDPS Act has not been made out by the petitioner in this case, and hence he prays for rejection of the bail of the petitioner. In support of his submission, he has cited the ruling of the Apex Court in the case of Union of India versus Namdev Ashruba Nakade, ASHRUBANAKADE, within bracket SLP within bracket criminal number 9792/2025. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record, including the scanned copy of the trial court records, which were requisitioned in this case. On perusal of the record, it appears that apparently the petitioner has been languishing behind the bars for last more than 1 year, 6 months. And stop. It also appears that though 6 out of total 9 prosecution witnesses have already been examined, however, since August 26, 2025, the trial has not progressed. This was the date when the PW6 was examined by the prosecution side. The apex court has observed in many of its rulings, including the rulings cited by the present petitioner in support of his submissions, that prolonged incarceration overrides the embargo of Section 37 of the NDPS Act. In the ruling cited by the petitioner, in the ruling cited by the learned additional public prosecutor, the apex court declined to grant bail to the petitioner of that case on the ground that the incarceration undergone by the petitioner of that case was not considered to be prolonged enough to give the benefit of bail to the said petitioner. It is pertinent to notice that the petitioner of that case was behind the bar for 1 year, 4 months at that point of time. Stop. This court is of considered opinion that under the facts and circumstances of a particular case, if the court comes to a finding that the incarceration of the petitioner is long enough to regard the same as infringement of his fundamental rights guaranteed to him under Article 21 of the Constitution of India, same would override the embargo of Section 37 of the NDPS Act. In the instant case, this court is of considered opinion that the petitioner who has been detained behind the bars for last more than 1 year, 6 months, however, the trial has not progressed for last 5 months. That is, since 26/8/2025, there is no further progress in this case. Under such circumstances, this court is of opinion that the incarceration undergone by the present petitioner in this case may be regarded as long enough to override the embargo of Section 37 of the NDPS Act. As such, this court is of opinion that he is entitled to get bail in this case. Accordingly, the petitioner, the above named petitioner, is allowed to go on bail of rupees. How much is contraband? Rupees 1 lakh. Rupees 1 lakh with 2 sureties of like amount, subject to the satisfaction of learned Special Judge Dhubri with following conditions, NDPS conditions. This bail application is accordingly disposed of.
Your Lordship.
Yes.
Last order, Lordship. So whether embargo of Section 37 of the NSS override the violation of arrest number.
Yes. Only 36 has been violated.
Also, on judgment is the DK Basu case, Lordship. I have already submitted, Lordship.
Yes, Mr.
Yes.
Sharma.
Lordship will kindly take up DK Basu case.
Yes,
DK Basu, Lordship, was totally on a different footing, Lordship. This was regarding Lordship custodial debt. Lordship is well aware custodial debt and torture. And Lordship, in this case, it was formulated that compensation, whether it can be given to the victim's family. That is the primary subject matter of DK Basu case. And if Lordship kindly takes up DK Basu case, paragraph 36 for a moment, Lordship. Uh,
36.
35 are the guidelines with Lordship. Paragraph 35 is the guideline that were given, Lordship.
You have SCC citation. The printout from SCC.
Yes, it is this is not SCC, Lordship.
But citation is there, Lordship.
No citation is there, but paragraph numbering is not there.
So
So
I only have. Yes, if Lordship takes up.
which page?
I think, I'm sorry, Lordship, the guidelines, Lordship will find that page 13, in page 14. These are the guidelines, Lordship.
Yes.
He is concerned with, Lordship, the guidelines. Number 2. That the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may either be a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. It shall also be countersigned by the arrestee and shall contain the time and date of arrest. That is the violation which he is referring to. Then Lordship will kindly come to the just the next paragraph, Lordship, of the, after the guidelines, Lordship. Yes.
Failure.
Yes. Failure to comply with the requirements herein above mentioned shall, apart from rendering the concerned official liable for departmental action, also render him liable to be punished for contempt of court. And the proceedings for contempt of court may be that in any high court of the country having territorial jurisdiction over the matter. So, Lordship, direction, Lordship, are to the effect that the erring official will be liable for departmental proceeding and also for contempt. And one important thing, Lordship, before I proceed further, is that when this judgment was not in force, NDP was not taken into consideration, Lordship. Next, Lordship will kindly come to paragraph 54. I'll just point out, Lordship. Yes, last page, Lordship, page 21. Thus, to sum up, is now a well-accepted proposition in most of the jurisdiction that monetary or pecuniary compensation is an appropriate and indeed an effective and sometimes perhaps the only suitable remedy for redressal of the established infringements of the fundamental right to life of a citizen by the public servants, and state is vigorously liable for their acts. The claim of the citizen is based on the principle of strict liability, to which the defense of sovereign immunity is not available, and the citizen must receive the amount of compensation from the state which shall have the right to be indemnified by the wrongdoer. In the assessment of the compensation, the emphasis has to be on the compensatory and not on punitive element. The object is to apply balm to the wounds and not to punish the transgressor or the offender, as awarding appropriate punishment for the offense, irrespective of the compensation, must be left to the criminal courts in which the offender is prosecuted, which the state in law is duty bound to do. The award of compensation in the public law jurisdiction is also without prejudice to any other action, civil suit for damages lawfully available to the victim or their heirs of the deceased victim with respect to the same matter for tortious acts committed by the functionaries of the state. The quantum of compensation will, of course, depend upon peculiar facts of each case, and no straitjacket formula can be evolved in this behalf. So this goes on, Lordship. So what I have understood from the DK Basu Lordship, it relates to custodial debts which happened at that time, and the law was formulated to check the custodial debt, torture, and whether financial compensation can be given to the victim family by the erring or by imposing cost on the erring police officer. Here, Lordship, what is relevant is, Lordship, at that point of time, NDPS was not enforced and NDPS was not taken into consideration. Thereafter, Lordship will see Section 5 of the BNSS also, Lordship. It specifically states, Lordship, that when there is a conflicting provision, Lordship, the special act will prevail upon the CRPC. That, Lordship, is well aware. There is that maxim also, Lordship, which I will not bother your Lordship with. Section 5 on that aspect is, Lordship, of the BNSS, Lordship, if Lordship kindly fix it, Section 5. It specifically states, Lordship, that it does not override any special law that are in force, meaning thereby, Lordship, any specific procedural rules will remain valid, Lordship. It doesn't affect any special law or local law, Lordship.
Okay.
Now, Lordship will kindly take up this judgment, Lordship, of the Division Bench of the Calcutta High Court. It's a well-written judgment, Lordship. Lordship, there are several aspects that has been dealt in this judgment, Lordship, but I will, Lordship, only place reliance on Lordship will find in page number 2, paragraph capital C. Other things I am skipping, Lordship, but I will try to keep as short as possible. Paragraph C, Lordship has found it.
Yes.
Yes. The memo of arrest does not contain any column. As such, no signature of any member of the petitioner or a respectable person of the locality was obtained. This is in breach of the provisions of Section 41B CRPC and the mandatory direction of the Honorable Supreme Court in the case of DK Basu, when the accused raised doubts on the mode of arrest, contending that the arrest was not made in the manner claimed by the prosecution. The requirement of complying with Section 41B CRPC assumes great importance, and non-compliance therewith dilutes the restriction in Section so-and-so. And this was the submission made by the counsel for the petitioner, Lordship. That is why I read it, Lordship.
Okay.
Now, Lordship, straightway come to paragraph 17, Lordship. There are other factors, Lordship. I'm not going into all those things, Lordship.
17.
17, yes. This is the observation, Lordship. After going through, I will not take much of the time, Lordship. The other paragraphs are also relevant, but I will not bother your Lordship with all those. Lordship has found paragraph 17. Yes, paragraph 17. Is it
Yes.
page 30? Paragraph 17. The third point urged on behalf of the petitioner is that Section 41B CRPC was violated at the time of arresting the petitioner. Lordship has found it.
Yes, yes.
This is because the memo of arrest does not contain any column X. Therefore, no signature of any family members of the petitioner or a respectable person of the locality was obtained on the memo of arrest. This is also in breach of mandatory direction of the Honorable Supreme Court in the case of DK Basu. It was submitted that non-compliance with the requirements of Section 41B CRPC dilutes the restriction in Section 37. In this connection, reliance was placed on 3 decisions of the coordinate benches of the High Court only, Lordship. Thereafter, Lordship, paragraph 18. It is true that Section 41B of CRPC, which prescribes the procedure for arrest and duties of the officer making arrest, says that while making an arrest, the concerned officer shall prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made and will be countersigned by a person arrested. This was reiterated in the case of DK Basu. However, Section 37 of the NDPS Act was not in issue before the Honorable Supreme Court. The non-obstante clause in Section 37 gives that section overriding effect vis-a-vis all provisions of the Criminal Procedure Code. In my considered opinion, even when an arrest is made without complying the requirements mentioned in Section 41B CRPC, still bail cannot be granted in NDPS case without satisfying the two conditions mentioned in that section. An arrest made without complying the provisions of Section 41B CRPC would not per se indicate that there are reasonable grounds to believe that the accused is not guilty of the offense he is charged with and that he is not likely to commit any offense while on bail, as held by the Honorable Supreme Court in the case of Kasif, Lordship. It is mentioned above, Lordship. The provision of NDPS Act includes Section 37 thereof must be given a literal construction rather than a liberal construction, keeping in view the object of NDPS Act. Further, the NDPS Act being a special act, its provision including Section 37 must be held to prevail over the provisions of CRPC, which is a general piece of legislation. The maxim generalis specialis non derogant, meaning that when there is a conflict between general and special laws, the latter would prevail is where else. So that is the finding of the division bench of the Calcutta High. I am relying on this.
So if you arrest a person charged with an NDPS offense, you need not to follow 41B.
It is not need not, Lordship. The guidelines are there, Lordship. Those are procedural laws, Lordship.
Now, what is
He has
the,
been given 47, 48. He was produced before the court on the same date, and he was given the choice of counsel also.
what is
Lordship.
the corresponding provision of 41B in the
36? 36 of BNS.
36?
Lordship will have to see it came from Lordship DK Basu. It was incorporated in the CRPC, Lordship, from the. And there are several guidelines, Lordship. Tomorrow, Lordship, if a police officer arrests one person without the.
No, now DK Basu observation has been incorporated in the statute. Now we have to look into 36, section 36.
Yes.
Question is whether violation of section 36
Yes.
would override
Yes.
embargo of section 37.
Yes. For that purpose, Lordship will also have to see the origin of section 36, Lordship, because it did not come from parliament. It came from Lordship, I'm sorry, Lordship. It came from the observation by the DK Basu, Lordship. The purpose behind 36. What was the purpose? That also Lordship has to take consideration. The purpose, Lordship, as I have already pointed out, Lordship, it came from DK Basu relating to custodial debt, improper arrest. That is the origin, Lordship. Now here, Lordship, the NDPS was not.
No, whether violation of 36 amounts to infringement of any fundamental rights.
And
Yes or
Lordship,
no?
let them show some
Yes,
judgment, Lordship, which
you-
states.
Lordship,
How 36 violation violates your fundamental rights?
Lordship, before that, Lordship, I want to cite on section 62, Lordship, of the NSS, Lordship. There is the last section of that chapter, Lordship, that no arrest shall be made except in accordance with the provisions of this Sanhita or any other law for the time being in force, providing for arrest, Lordship. This section itself says that arrest is illegal, Lordship. If any violation is there, then no arrest shall be made, Lordship. It's specifically mentioned, Lordship, which is the law came in 2023.
So the NDPS will prevail over the CRPC, Lordship. The provisions of NDPS will always prevail over CRPC, Lordship. Regarding arrest, Lordship, they have to show something, Lordship, where it states that violation of the witnesses not signing in the arrest memo will lead to bail in a NDPS case, where Lordship 37 is there, which has been held by a number of judgment in the Supreme Court, Lordship, day in and day out, Lordship, that cannot be given any bail without consideration of section 37.
This is your first bail application.
Lordship, this is file. Yes. First, Lordship. Lordship, I want to refer a judgment given by the Supreme Court, Lordship, on more. para 8, Lordship, in case 4, Lordship. Once a court, while dealing with the bail application, finds that the fundamental rights of the accused under Articles 21 and 22 of the Constitution of India have been violated.
How, in this case, how it has been violated?
Violated because the Article 21 violated, this is the personal liberty. Article 21 itself is the procedure, personal liberty should not be curtailed except procedure established by law, Lordship. And established by law, Lordship, that is the BNSS is the Lordship. That is an established law,
Procedural
Lordship.
irregularity
Okay.
and prejudice, Lordship, that also has to be taken into consideration, Lordship. What was the prejudice that has been caused to him, Lordship? On the same date, Lordship, after a few hours, he was given 47-48. So what was the prejudice, Lordship?
Heard Mr. S. Hussain, learned counsel for the petitioners. How many petitioners are there? Learned counsel for the petitioners. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely Amirul Islam alias Nengra Police and Ashraf Ali, who are detained behind the bars since 6/4/2025. How many days you are behind the bars?
So as on today, Lordship,
Within bracket,
73,
within bracket for last 273 days,
76.
76 days. In connection with special NDPS case number 45/2025 arising out of Mankachar Police Station case number 53/2025. The section 22C/29 of the NDPS Act, 1985, pending before the Court of Learned Special Judge, South Salmara. The gist of accusation in this case is that on 6/4/2025, one Deepak Bargayari, Inspector of Police. No, sorry. One Pooja Hajorika, Sub-Inspector of Police of Mankachar Police Station, had filed an FIR before the officer in charge of Mankachar Police Station, inter alia, alleging that on a secret information has been received through reliable sources regarding trafficking of drugs and selling of Yaba tablets in the house of one Amirul Islam alias Nengra Police, within bracket, petitioner number 1. Accordingly, a search team was constituted and the house of Amirul Islam was searched on that day. During search operation, about 6 bundles containing 10 packets, within bracket 12,000 Yaba tablets, were recovered from the house of Amirul Islam, within bracket petitioner number 1. The total weight of the recovered Yaba tablets was found to be 1311 grams. Now, where Ashraf Ali was found?
on the basis of court statement lordship, that is the petitioner number 1, who has been arrested. Lordship.
Later on the basis of statement made by Amirul Islam, the petitioner number 2, Ashraf Ali, was also arrested in connection with the aforesaid recovery of drugs. On receipt of the aforesaid FIR, Bankachar PS case number 53/2025 was registered under section 22C/29 of the NDPS Act. An investigation was initiated. Charge sheet has been filed.
Lordship,
When? Where is the charge sheet?
charge sheet,
After completion of the investigation, the charge sheet
was filed on lordship 37/25.
30, charge sheet was laid against both the above named petitioner under section 22C/29 of the NDPS Act. Stop. At what stage it is pending?
Lordship.
At what stage trial is pending?
Evidence is test, lordship.
Huh?
Evidence is test, lordship.
Evidence stage. The trial is presently pending at the stage of recording of prosecution witnesses. Stop. Learned counsel for the petitioner has submitted that the petitioners are seeking bail in this case mainly due to violation of mandatory statutory provisions contained in section 36 of 36 as well as section 62 of BNSS. He submits that. Where is the arrest memo?
Arrest number is 51 and 52, lordship.
He submits that the aforesaid statutory provision BNSS requires he submits that as per section 36 within bracket small b of the BNSS 2023, at the time of arrest of an accused, the arresting authority is required to prepare a memorandum of arrest which shall be attested by at least one witness who is the member of the family of the person arrested or a respectable member of the locality where the arrest is made. And same is also to be countersigned by the person arrested. However, he submits that in the instant case, at the time of arresting the present petitioner, where are the arrest memo?
Case number 51 and 52.
50?
51 and 52.
However, at the time of preparation of arrest memo in this case, though the signature of the present petitioner was obtained in the arrest memo, however, no signature of at least one witness who is a member of the family of the arrested person or a respectable member of locality has been obtained. He therefore submits that the arrest memo has not been prepared as prescribed by section 36 within bracket B of the BNSS. He further submits that section 62 of the BNSS provides that no arrest shall be made except in accordance with the provisions of the BNSS or any other law for the time being in force providing for arrest. Learned counsel for the petitioner submits that the arrest in this case is therefore made in contravention of the statutory provision, and therefore his fundamental right under Article 21 is violated. He also submits that such an infringement of fundamental rights would override the embargo of section 37 of the NDPS Act, and as such, the petitioners are entitled to get bail in this case. In support of his submissions, learned counsel for the petitioner has also cited following ruling of the Apex Court, number 1 D.K. Basu versus State of West Bengal, reported in what is the SCC citation? 1997 1 SCC
Page 416.
416, as well as the ruling of the Apex Court in the case of Directorate of Enforcement versus Subhash Sharma, within bracket specially petition criminal number 1136/2023. On the other hand, learned additional public prosecutor Mr. B. Sharma has vehemently opposed the grant of bail to the petitioners on the grounds pleaded by them. He submits that in the instant case, huge quantity of contraband was recovered from the possession of petitioner number 1, and there are evidence regarding complicity of petitioner number 2 in the offense alleged in this case. He submits that in view of the recovery of commercial quantity of contraband from in this case, the embargo of section 37 would be applicable to this case. He further submits that section 36 of the BNSS is in pari materia with section 41B of CRPC, which was enacted after the observation of the Apex Court in the case of D.K. Basu versus State of West Bengal. Supra, stop. He further submits that at the time when the judgment of D.K. Basu versus State of West Bengal was delivered, the NDPS Act was not in force, as it was enacted much later than the delivery of the judgment in D.K. Basu's case. He also submits that apart from the fact that while delivering the judgment in DK Basu case, the apex court was not considering the provisions of NDPS Act as it was not in existence at that point of time. It had only indicated in the judgment that failure to comply with the guidelines issued by the apex court in the aforesaid case would invite departmental action against the erring police officer and would also and the said officer would also be liable for punishment of contempt of courts. He submits that as to what would be impact of violation of such directions on an arrest effected under special act like NDPS Act was not considered by the court at that point of time. He submits that since the NDPS Act is a special act, hence under provisions of Section 5 of the BNSS, it would prevail over the general law laid down, general procedures laid down under BNSS. He also submits that though the requirement of obtaining the signatures of an independent witness in the arrest memo is a statutory requirement under Section 36 of the NDPS Act. However, any violation of the said requirement would not override the embargo laid down by the other statute that is under Section 37 of the NDPS Act. In support of the said submission, in support of his submission, learned counsel for the learned additional public prosecutor has cited a ruling of the High Court of Calcutta in the case of Hero Sarkar versus Union of India within bracket CRM within bracket NDPS 445/2025. He submits that in the aforesaid case, the issue involved was similar to the issue involved in this case as to whether the violation of statutory requirement of Section 36 of the BNSS or the guidelines issued by the DK Basu by the apex court in the case of DK Basu versus State of West Bengal within bracket Supra would result into granting of bail to an accused facing charges for possession of commercial quantity of NDPS Act or not. He submits that in the said case, the High Court of Calcutta came to a finding that due to the existence of non-obstant clause in Section 37, it gives overriding effect vis-a-vis all provisions of the Criminal Procedure Code within bracket BNSS. And therefore, he submits that if a statutory requirement under general law, that is BNSS, is violated, same would not entitle an accused facing charges under NDPS Act for possessing commercial quantity of contraband to get bail. Stop. I have considered the submissions made by learned counsel for
Lordship, sorry for interrupting. Lordship, will kindly take up section 36 of the BNSS for a moment.
yes,
Lordship has already perused section 36, B.
B.
B, Lordship is, that is the issue, Lordship, prepare a
Yes.
memorandum arrest which shall be one, attested by at least one witness that Lordship is perused. Two, Lordship is perused countersigned by the person arrested. Lordship, kindly peruse C.
Yes,
Inform the person arrested unless the memorandum is attested by a member of his family that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest.
okay.
So that is my submission. Lordship.
Learned counsel for the learned additional public prosecutor further submits that the scheme of section 36 is such that the obtaining of signatures of at least one witness who is the family member of the arrested person is not mandatory, inasmuch as section 36 within bracket C lays down a duty on the arresting authority to inform the person arrested in the event that in the event of non-obtaining of, in the event the memorandum is not attested by member of his family, that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest. Stop. I have considered the submissions made by learned counsel for both sides. I have also perused the materials available on record, including the scanned copy of the special NDPS case number, Kimanasila case 42/2020. I have also gone through the rulings cited by learned counsel for both sides. The question to be determined by this court while considering the instant bail application is as to whether any infringement of procedural requirement as laid down under section 36 within B would entitle an accused to get bail in a case involving offense for possessing commercial quantity of contraband by overriding the embargo laid down under section 37 of the NDPS Act. Remaining part I will dictate in chamber. Today I will dispose of.
DK Basu case law. Case number 15 Lordship. That the requirements referred to above follow from articles 21 and 22(1) of the Constitution of
Where?
case number 15 Lordship. That is fourth para Lordship. Fourth para.
Page number?
Case number 15 Lordship.
Yes, I have
Para.
marked it.
Yes.
Fourth para.
Fourth para Lordship. The requirements referred to above follow from articles 21 and 22(1) of the Constitution and need to be strictly followed. This would apply with equal force to the other governmental agencies also to whose the defense has been made earlier.
On 20, I will deliver. After vacation, I have to go. Heard. Let this case be listed for delivery of orders on 20 January. No, this question is important. It is not dealt with by any other coordinate bench of this court.
It has been, copy किसने नहीं? Coordinate bench.
I have already submitted coordinate bench.
I am Justice Anjan Kalita.
Yes. That's
Okay, so if I differ, then it will go to larger bench. And if I concur, then you will get bail.
So I
Fair.
will not elaborate on C lordship
No, C is,
unless
C appears. What do you want to elaborate?
nothing much lordship, only that it is not mandatory lordship. The language itself states
It appears. 20.
so if the 47, 48 has been adequately given lordship, that is my submission. lordship.
Okay.
It's like a coordinate violation. Published.
I cannot reject your bail prayer. If I disagree with the coordinate bench, it has to be referred to larger bench. No, when one coordinate bench has already interpreted the question formulated by this court, that 36 is mandatory.
Yes.
So I have to only see that whether I concur with the coordinate bench or I differ. If I differ, then this has to be referred to larger bench.
Item 19 and 20.
May I please your lordship? Lordship, request on the entire case diary of the trial.
Case diary is there.
Entire case diary. Because of both the accused person not identified with TIP and one video footage is there.
Lordship, can some other day be fixed for the matter lordship? Because the records lordship, it appears lordship, K. Bush had gone through some parts of the case diary.
So it will be after vacation.
See, long.
On reopening day, we'll fix.
261 days lordship. The trial is not progress till today, after in month.
Lordship can be taken up on 20 lordship,
20.
20.
Heard Mr. M.A. Mondal. There are two cases.
Yes, Lord, same case. Lord.
Same case, say, separate orders. Yatat M.A. Mondal and in other case,
K.R. Bora.
A. K.R. Bora.
20 item.
Item number 20, K.R. Bora. In item number 19, M.A. Mondal. Learned counsel for the petitioner, also Mr. B. Sharma, learned additional public prosecutor. It appears that the scanned copy of the trial court record along with case diary has been received. However, as the scanned copies are voluminous, learned counsel, learned additional public prosecutor submits that this matter was earlier dealt with by another additional public prosecutor, Mr. K. Bush. Therefore, he prays for an adjournment. The prayer is allowed. Let this matter be listed on 20 January.
Lordship, the last date as per the records was in the month of November, Lordship. So maybe as
No, we are concerned with case diary.
Yes, there.
Any material against them or not regarding the progress of the trial.
Mass problem.
After some time. You are there?
There are two bail petition. I filed the earlier bail petition, my lord. That earlier bail petition during pendency, second bail petition was filed. And if second bail petition, my lord, bail was granted. Now, my lord, my petition has influence. So question is, how this second bail petition during pendency of earlier bail petition was filed?
No, Ms. D. Ghosh will be required. The petitioner. Let her come. We'll take it up after in the second half. Or if she does not appear, we'll defer it.
Lordship, I'm sorry, not in the second hour if possible.
Then,
It
We-
may be after vacation.
okay. None has appeared. Item number, Kiman?
27, 28.
Item number 27 of the order लिखेंगे. Miss, none has appeared for the petitioner on call. Mr. M. A. Sheikh appears for the petitioner in bail application number 2029/2025, which has already been disposed of. Mr. B. Sharma, Learned Counsel. Yes, Ms. Ghosh, you are there.
If the IA Lordship service awaited is written as per the office note.
No, Mr. Rashid is appearing for.
Oh.
Mr. Sheikh is appearing for the,
Earlier bill petition, my lord.
Earlier bill petition.
Bill petition, my lord, the BA number 226 of 24.
for the petitioner.
Yes, my lord.
That is the respondent number 2.
In this case, sorry, I apologize. It's 20, it's not 27, no? 27, 28.
Yes, in 27,
So two bail applications were there. One is bail application 2401 Lordship, and one is bail application 2029.
2029 has been disposed of. Bail was granted.
No, Lordship, bail was granted in, I have filed an IA in bail application number 2401, which was disposed of.
Okay.
In 2401, I have filed because this bail application was filed subsequently. Earlier bail application was Lordship 2029, which was pending, and the present applicant, who is the informant, has received the notice. She has filed her objection, and that case was pending before this honorable court, Lordship. While that case was pending before this honorable court, meanwhile, subsequently, they have filed, suppressing this fact, they have filed bail.
Who is Abdul Ali?
Abdul Ali is the accused, Lordship, and I'm the informant.
Abdul Ali is the petitioner in bail application 2029.
And both the bail applications, Lordship.
So you can represent Abdul Ali.
Who, my lord? Myself.
Yes.
In subsequent bill petition, I cannot, because I am not the advocate. My petition is 2029 of 2025. I cannot represent. Another advocate filed this petition. He is to answer how the subsequent bill petition.
How you took steps? How you took steps through?
Through registry, Lordship, and that as per the office note dated 5/1, that is awaited through some officer in charge.
Then you take information regarding service. We'll fix this case after vacation.
Yes, Lordship.
Heard Miss D. Ghosh,
Then
Learned.
both applications should come together.
It will come together. Heard with Miss D. Ghosh, Learned Counsel for the petitioner. Common order koribo. Common order. Heard Miss D. Ghosh in IA within bracket, Learned Counsel for the petitioner in IA within bracket criminal 1140/2025. Stop. Mr. M. A. Sheikh, Learned Counsel for the petitioner in bail application number 2029/2025 is also present. However, he submits that he has not been authorized by the petitioner to represent him in bail application number 2401/2025. Mr. B. Sharma, Learned Counsel, Additional Public Prosecutor, is also present. On perusal of the office note dated 5/1/2026, it appears that the service report in respect of notices issued to respondent number 2 through officer in charge of jurisdictional police station is awaited. Learned additional public prosecutor is requested to take information regarding service of notice upon respondent number 2. And let this court know about the fate of the same on the next date fix. You take information. Let this matter be listed on 4th of February.
The question on what authority represented how he made this whole statement look.
And
My lord,
lordship,
advocate is advocate. Another thing is this, that particular person, Abul Hussain, that accused, how he authorized the second advocate.
No,
To
we
file
cannot
a petition.
shift the blame to the.
Second advocate, you are the second advocate.
No, my lord, I'm not the second.
Your petition is this
2029,
earlier petition.
yes.
Okay.
No, my lord. It is, advocate is all right, man. Advocate is to answer, but first answer is to be given by Abdullah.
No, it is not
How
authorized.
second time
No,
authorized?
In my respectful submission, it is not authorized. When any advocate files a bail application, lordship, there is a categorical statement that is to be made.
yes,
That no other
lordship.
bail application is pending. So the advocate also has to be put into notice. lordship.
My lord,
Now,
I'm
why
not,
is
I'm
it-
defending
why-
the
why is it
advocate, but
taking the side of
statement,
the-
my lord,
No, no, just
that
a minute.
affidavit, my lord, that
Why-
affidavit
why
is
is it
filed by the
trying to defend
petitioner,
the
not by the
Okay,
advocate.
let the, no, I got your point. I got your point. If there is a wrong foul play by the advocate concerned, there might be some foul play also. Okay, but let the notice be served. Let us wait for the,
Yes. For the notice, but affidavit shown in both the petition
By the
is,
advocate.
by the father of the accused and father of the bail applicant, and age is difference is there.
okay, we'll examine that.
These all
Fix
aspects
on
are there.
20
lordship.
4/6, 4/2, 4th of February.
Lord, one thing, my lord, I want to, what my learned friend submit, my lord. I do not agree with him. My lord, we the advocate, he used to identify, all right, but. his
No,
statement
no,
is
we
made
are
by-
not going into the case today.
My lord,
Reserve everything for 4th of February.
what my learned friend submitted, that advocate has
No,
responsibility.
you reply on 4th
My
of
lord.
February.
On that, my lord, my humble submission before your lordship, it is an affidavit sworn in by somebody. How they responsibility fixed on advocate, that is the thing. I am not the advocate, but this is the position,
Okay, we'll examine that.
my lord.
Service or affidavit, I say. Notice has been served on all the parties.
Except six, and there are two parties, my lord, on whom we could not serve. My lord, junior will point it out to your lordship.
Yes, Mr. Jain.
We have made a mention in our affidavit.
Mr. Jain,
Lordship.
on whom notices are not served,
6 and 14 is
6 and 14. Remaining others notices are served by Dusty Mood,
Lordship, to speed post. Lordship, we have annexed the
track consignment.
track consignment.
Okay, okay. So we can go ahead with the hearing as the respondent number 1 is the only objecting party.
Yes, yes.
Yes.
And it's only, it's maintainability of this suit, of the petition.
Maintainability, or we can,
Suitability of the CRP, my lord.
yes,
I'm
yes.
Primarily on that, my lord.
Only on the-
If your lordship
So I'll
holds
give a
it
very
not
nominal-
maintainable, that's the end of the matter.
I'll give a very minimal factual background, which
Okay.
I consider
Yes.
necessary, my lord.
You have to make your submissions
Yes.
first. Yes.
My lord, this pertains to the dispute, my lord, between
partners of a firm, which was, my lord, constituted by way of a partnership deed in the year 1967. Now, my lord, a title suit was filed before a learned civil judge, senior division in Jorhat, title suit 38 of 2012, which your lordships have been filed by the petitioners at page 42. Now, I will not bother your lordships in going into the details too much.
28 of 2012.
No, title suit 38 of 2012, my lord.
Okay.
Now, my lord.
By whom?
By me.
Okay. You are one of the partner of the.
Yes, in fact, I am the only sole surviving partner in the firm, my lord. So, my lord, one of the reliefs that are now being pressed by me before the learned arbitrator, before whom the arbitration proceedings are pending, is a declaration that I am the sole surviving partner, my lord, because all the other partnerships.
Which firm?
My lord, the partnership firm.
Name of the
My lord,
firm
the
is?
partnership firm is respondent number 2, my lord. It's called. I'm sorry, it's respondent number 3. It's called Boloma Tea Company.
Boloma.
Boloma, Messrs. Boloma Tea Company. It's respondent number 3.
Yes.
Now, my lord, in the suit, some of the defendants, my lord, to be more precise, respondent number 5 before your lordship, Kishore Kamal Besborua, who is a legal heir of one of the partners, my lord, who passed away in the year 2009, who's respondent number 5, Kishore Kamal Besborua. Now, my lord, he had filed an application under Section 8 of the Arbitration and Conciliation Act 1996, saying that in the partnership deed, there is an arbitration clause, and therefore the disputes are covered by the arbitration clause.
What was the dispute in the suit?
Well, there are numerous prayers, my lord. I can take your lordship through the prayers. But, my lord, today, because we have filed an arbitration proceeding, in that particular suit, my lord, there were reliefs claimed against the partners, and there were also, my lord, reliefs claimed against the petitioners, the companies. So, in short, my lord, in a nutshell, the case was that funds of the partnership firm were unlawfully diverted, misappropriated, and diverted into these companies. In fact, the companies also, we had some shares. So the companies were also made parties because they were necessary parties in the suit. And on that ground, the Section 8 filed by Kishore Kamal Besborua, respondent number 5, was rejected by the learned civil judge, senior division.
Okay.
Well,
Yes.
against that, Kishore Kamal Besborua preferred a civil revision petition, my lord, before this honorable court. And that order of the learned civil judge, senior division,
CRP
was
number?
CRP 185 of 2016, which your lordships will find at page 82, my lord, of the report.
Okay. What happened in that?
My lord, the Section 8 order of the learned civil judge, senior division, was affirmed by this honorable court.
Trial court
court-
refused to refer it to arbitration.
Yes, refused to refer it to arbitration.
Okay.
Saying that, my lord, the suit cannot be split because there are relief claims against these companies also, the petitioners before your lordship today. So
Okay.
there are relief claims against them. They are not parties to the arbitration agreement. And therefore, my lord, the suit cannot be split and therefore it cannot be referred to arbitration. So holding so, the Section 8 was rejected by the trial court. Against that, Kishore Kamal Besborua went up in a CRP before this honorable court, which your lordships will find at page 82, my lord, annexure F. By way, my lord, of an order dated 1st November 2021, the CRP was rejected. I will only show, my lord, the relevant part in this. Paragraph 7, if your lordship may come, page 89. I'll just read, my lord, from the first sentence. The defendant number 1 is the estate of late Dr. Neil Kamal Besborua, and defendant number 3, 4, and 5 are his legal heirs. Late Dr. Neil Kamal Besborua was the uncle of the plaintiff. Defendant number 6 and 7 are private limited companies wherein late Neil Kamal Besborua was the managing director of the said two companies till his death on 1st August 2009. Defendant number 5 is the wife of late Dr. Neil Kamal Besborua and director of defendant number 7 company. Defendant number 9 and 10 are the chartered accountant firms of D2, 6, and 7. D11 and 12 are both partners in D2 partnership firm. D13, 14, 15, and 16 are the legal heirs of one of the founding partners of D2 partnership firm. From the aforesaid relation amongst the defendants, in my considered opinion, they are necessary parties in the suit for rendition of accounts of the partnership firm, defendant number 2. On perusal of the plaint, it is found that the plaintiff made specific allegations against each and every defendants, including the allegations of fraud. The respondent plaintiff prayed for various reliefs, mainly for declaration and for direction to the defendants. As there are allegations of fraud at this stage, it would not be proper to enter into the issue of misjoinder of necessary parties in the suit. I'll skip the rest of it. Paragraph 9, my lord. In view of the discussion made herein above, it is also my considered opinion that the learned court below rightly exercised its jurisdiction and came to the finding that the petition under section 8 of the act is liable to be dismissed. The cause of action for the suit, though partially arose for violation of terms and conditions of the partnership deed among predecessor in interest of the plaintiff respondent. However, considering the consequential reliefs, I am not inclined to interfere with the observation made by the learned court below. In view of the same, I do not find any merit in this revision petition, and the same stands dismissed, no cost. Well, against that, Kishore Kamal Besborua went up to the Supreme Court by way of an SLP, my lord. The order, my lord, is extremely important. Page 91, the next page, my lord.
Yes.
I'll skip the first 4 paragraphs. In fact, the first 5 paragraphs. My lord, I must point out here that the SLP was served on the petitioners. The office report which I have filed with my reply shows that their service was complete. They were aware of the SLP, but they never entered appearance. The companies, my lord, who are today as who are appearing before your lordship as petitioners today. Now, my lord, paragraph 7 of at page 92, if your lordship sees, paragraph 6, heard learned counsel for the parties and carefully perused the material placed on record. Both sides seek appointment of a sole arbitrator in terms of clause 5 of the partnership deed dated 16th November 1976, executed between the parties, which reads as follows: that R.K. Besborua and N.K. Besborua, 2 of the partners, shall jointly manage the financial affairs and bank accounts of the firm. Any dispute or difference, unless otherwise agreed, shall be referred to the other partners in the first instance, and if not resolved, shall be referred to the arbitration of mutually agreed third party. On a perusal of the aforesaid clause, we find that the parties agreed to arbitrate their dispute and differences, as the partnership deed clearly stipulates that any dispute or difference, unless otherwise agreed, shall be referred to the other partners in the first instance, and if not resolved, shall be referred to arbitration of mutually agreed third party. We accordingly, with the consent of learned counsel for the rival parties, consider it just and appropriate to appoint Justice retired B.P. Kotaki, a former judge of the Guwahati High Court, as the sole arbitrator to adjudicate the dispute between the parties. The arbitrator appointed by us will proceed with the matter after complying with the provisions of Section 12 of the Arbitration and Conciliation Act 1996. Needless to mention that the fee of the arbitrators, I'll skip this, my lord, paragraph 11. Keeping in view the age of respondent number 1, that is, my lord, my client, who is stated to be an 80-year-old pensioner, we request the learned arbitrator to permit him to appear through virtual mode in the arbitral proceedings. Now, my lord, the SLP was disposed of. Then the arbitration proceedings commenced before the learned arbitrator. And, my lord, at this stage, I'll show from my reply that they were served, my lord, in the SLP. If your lordship may kindly have my reply, page 407.
Just a minute. Yes.
Lord, we'll see the office report of the, which is downloaded from the Supreme Court of India's website, my lord, at page 407. My lord, has it?
Yes.
You know, it shows the court number, item number. Then your lordship will see the matter, office report. The matter above mentioned was listed before the Honorable Court on so and so, 13 July 22. When the court was pleased to pass the following order, issue notice returnable on 26th August 22, liberty to serve the respondents with vesting notice also. The possibility of amicable settlements through ages of mediation shall be explored on the next date of hearing. It is submitted that there are 14 respondents in the instant matter pursuant to order quoted above. Show cause notice was issued to all respondents through registered AD post as well as Dasti on 21st July 22 and 19th July 22 respectively. Mr. Munawar Naseem has on 22nd August 22 filed Wakalatnama appearance on behalf of R1, but he has not filed counter affidavit on his behalf so far. As per India Post tracking report, notice has been delivered to respond number 2 to 13, but no one has entered appearance on their behalf so far. Unserved cover containing notice has been received back in the registry with postal remark, no such person has given notice. My lord, then counsel for petitioner as on 24th August 22 has filed affidavit of Dasti service with proof of service which shows that R1 to 13 have been served by Dasti and R14 has been served by email, but no one has entered appearance on their behalf so far. Similar office reports are there in the following pages also. 409 Millard, this is an office report of 9 September 22 where Millard it shows that Millard, an advocate, Ms. Pallavi Sharma, advocate, has on 26th August 22 filed Wakalat appearance on behalf of R7 and 8. So, and the page 410, second sentence, service is complete, Millard. So, Millard, service stood complete and all the respondents who are the petitioners in this CRP, Millard, were served, but they chose not to participate in the SLP, Millard. And an order was passed referring all the parties in the dispute to the learned arbitrator, Millard. So that order of the learned Supreme Court, Millard, in the SLP has attained finality. They have not taken any steps to file a review of that order, Millard. What happens then, Millard? The arbitration proceedings commence and they file an Order 7, Rule 11 application before the learned arbitrator. Now, Millard, that is treated as a Section 16 application by the learned arbitrator and is disposed of by the impugned order, Millard. Well, just one aspect which I would like to point out here, page 312 at page 313 of the record, 312.
Arbitration Act. So. Just a minute.
Yes, please.
Yes.
312, Millard, at page 313. This is annexure L, Millard, of their CRP. This is the Order 7, Rule 11 application, Millard. I'm sorry, this is for deletion of party. Order 7, Rule 11, read with Order 1, Rule 10, Sub Rule 2, Millard.
Page number 300 and
312, Millard. Similar applications were filed by the other companies also. There are 3 companies in all, Millard. One is
yes.
this is filed by Bokahola Tea Company, Millard, page 312. Millard, what I would like to point out is paragraph 6 here. They ask for deletion. At paragraph 6, Millard, they acknowledge that the respondent number 5, they were respondent number 5, Millard, in the arbitration proceedings. Paragraph 6, Millard, they say that the respondent number 5 having some business transactions, that is purchase of green leaf and payment made thereof with respondent number 2. That is the partnership firm. Number 2 is the firm and is not involved in the dispute regarding share interest control of respondent number 2. Our whole case, my lord, largely is that funds were misappropriated, diverted to the company. Later on, my shareholding in the company was also diluted. That is our case insofar as how the companies are necessary parties in the proceedings before the learned arbitrator. Now, my lord, paragraph 6, they acknowledge that the companies also had business transactions, business dealings with the partnership firm. Similar applications, my lord, were also filed by the petitioner number 2 before your lordship, Kasojan Tea Company, which is at 318. And 324, my lord, is Bokahola Investment Private Limited. So all the three companies file applications for deletion, which were treated as Section 16 application by the learned arbitrator and disposed of, my lord, on 4th of August 2025. Your lordship will find this order, which has been challenged by them in the CRP at page 20 of the CRP. Just a couple of paragraphs I'll read, my lord, because I don't want to go into the merits, my lord. Your lordship may have paragraph 8 at page 25. The present respondents number 5, 6, and 7, though were made parties in the said proceeding before the
5, 6,
honorable.
and 7 are the companies.
Yeah, they are the companies who are the petitioners before your lordships today. 5, 6, and 7, they had moved the applications, my lord,
Yes.
before the arbitrator. Though were made parties in the said proceeding before the Honorable Supreme Court and were served, they did not contest the same. Our 5, 6, and 7 who were served, therefore knew Kishore Kamal Besborua, respondent number 4, took up the plea of group of companies to bring in the said respondents under one umbrella, that is arbitration proceedings, which not only encompasses parties who are signatories to the arbitration agreement, but also the non-signatories. The said proceeding before the Honorable Supreme Court, however, was contested by respondent number 1, 2, 3, namely Manush Kamal Besborua, Bolomar Tea Company, and Sri Prabhat Kamal Besborua. They were represented, my lord, before the Supreme Court, who also did not raise any issue before the Honorable Supreme Court. Now, my lord, this is important because Sri Prabhat Kamal Besborua, respondent number 3 in the arbitration proceeding, he was represented, my lord. And why this is important, my lord, is because Prabhat Kamal Besborua's wife is the authorized signatory who has signed this CRP, my lord. Now, my lord, I'll come, my lord, to paragraph page 26, my lord, from the top of the page. The claimant, that is me, has also claimed shares each in the profit of respondent number 5, 6, and 7 companies. Declaration that R5, 6, and 7, as well as R1, 3, and 4 have illegally enriched themselves at the expense of R2 partnership by siphoning of the businesses and profit of R2, and to give the claimant his share of profits has also been claimed apart from other claims. The claimant in the SOC has also alleged fraudulent and manipulating conduct of Dr. Neel Kamal Besborua as well as R3 and 4, benefiting R5 and 6 to the detriment of R2 partnership, and thereby also increasing shareholding of Dr. Neel Kamal Besborua in R5 and 6. The claimant has also claimed comprehensive audit of assets, accounts, and functioning of R2 and of R5, 6, and 7 to discover all the manipulations, misrepresentation, losses, damages, loss of profits, and siphoning of funds from R2 by R1, 3, 4, 5, 6, and 7. It has also been contended in the SOC that late Dr. Neel Kamal Besborua was the managing partner of R2 partnership, who was also the managing director of R5 and 6 till his death on 1st August 2009. And after his death, the respondent number 3, Prabhat Kamal Besborua, who during the lifetime of Neel Kamal Besborua had been assisting him in the managing the affairs of R2 and R5 and R6, started managing the affairs of R2 and of R5, 6, and 7 as the managing director. I'll skip the rest of it, Miller. They refer to the CRP. I'll come, my lord, to the conclusion. They refer to the group of companies doctrine, my lord. And their main challenge in the CRP is that the group of doctrine companies is not applicable, my lord. Paragraph 16, if your lordship sees at page 28 bottom, law relating to the application of doctrine of group of companies is therefore no longer res integra. There cannot be two opinions that a non-signatory company can be impleaded to single composite arbitration by invoking the group of companies doctrine on certain circumstances. It is always not necessary that the company, for being impleaded in an arbitration proceeding, has to be a signatory to an arbitration agreement between the company and other respondents in such arbitration proceedings. As discussed above, the respondent number 5, 6, and 7 did not contest the plea taken by Kishore Kamal Baisborua, R4 in SLP filed before the Honorable Supreme Court for invoking the doctrine of group of companies. So this was the ground, my lord, group of companies ground, which was specifically taken by Kishore Kamal Baisborua, my lord, before the Supreme Court. By the aforesaid order passed by the Honorable Supreme Court, it was not left to the arbitral tribunal to decide whether the non-signatory is bound by the arbitration agreement. The contention that that respondent number 5, 6, and 7 are also subjected to civil suit at the same time is not acceptable in view of the aforesaid matter passed by the Honorable Supreme Court, referring all the disputes or differences for arbitration. But I will now straightaway take your lordship to the law as settled by the Honorable Supreme Court insofar as 16 is concerned. My lord would be conscious of 16, particularly subsection 5 and 6 of 16, my lord. And my lord, the zero scope of interference, my lord, by any court pending disposal of the arbitral proceedings. Section 16, if your lordship may have.
Yes.
Competence of arbitral tribunal to rule on its jurisdiction. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to the existence or validity of the arbitration agreement, and for that purpose, an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract, and a decision by the arbitral tribunal that the contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. A plea that the arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. However, a party shall not be precluded from raising such a plea merely because that he has appointed or participated in the appointment of an arbitrator. A plea that the arbitral tribunal is exceeding the scope of its authority shall be raised as soon as the matter alleged to be beyond the scope of its authority is raised during the arbitral proceedings. The arbitral tribunal may, in either of the cases referred to in subsection 2 or 3, admit a later plea if it considers the delay justified. Subsection 5, my lord. The arbitral tribunal shall decide on a plea referred to in subsection 2 or subsection 3, and where the arbitral tribunal takes a decision rejecting the plea, as done, my lord, in our case, continue with the arbitral proceedings and make an arbitral award. A party aggrieved by such an arbitral award may make an application for setting aside such an arbitral award in accordance with section 34. My lord,
16.6.
yes, my lord. So subsection.
That is your case.
Yes, it makes it extremely clear beyond the pale of doubt, my lord, that they have to await the final award and then, my lord, go to the section 34 court. And 37, my lord, section 37 also I would like to draw your lordship's attention to.
No, read 5 again.
Yes, my lord. The arbitral tribunal shall decide on a plea referred to in subsection 2 or subsection 3. And where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceedings and make an arbitral award.
So before making of arbitral award,
My lord.
whether the decision under 16.2 by the arbitral tribunal can be challenged.
It cannot be, my lord. Before the award, not a, my lord, if the section 16, my lord, is allowed and the arbitral tribunal holds that the tribunal does not have the jurisdiction and the section 16 is allowed in favor of the party who moves the application under section 16. Then, my lord, the party who's aggrieved by such an order can go under section 37.
That
But
is-
if, my lord, the section 16 application is rejected, then the only remedy to the aggrieved party would be to await the final award, my lord, and go under section 34. That is clear from section
In lieu of
36.
section.
Subsection 6.
6.
Yes.
That 16(6).
Yes, my lord. A party aggrieved by such an arbitral award may make an application for setting aside such an arbitral award in accordance with 34. Now, this becomes clear if your lordship sees section 37 for a moment.
So they will have no remedy.
No remedy,
against-
my lord. They have to await the final decision in the arbitral proceedings, that is the final award, my lord. And the Supreme Court has settled this position. I'll come to the judgments, my lord. But, my
They
lord,
cannot prefer civil division.
no, my lord. That's been very well settled by the Supreme Court, at least in two decisions, and
Okay.
also followed by the high courts. But at 37, if your lordship now sees, it makes the position more clear. Section 37, it's under chapter 9, under the headings appeals, appealable orders. Notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders and from no other orders to the court authorized by law to hear appeals and original decrees of the court passing the order, namely, refusing to refer the parties to arbitration under section 8, granting or refusing to grant any measure under section 9, setting aside or refusing to set aside an arbitral award under section 34, subsection 2. An appeal shall also lie to a court from an order of the arbitral tribunal accepting the plea referred in subsection 2 or subsection 3 of section 16. My lord may note this. Accepting the plea.
Okay.
So if the plea under subsection 2 or subsection 3 of section 16 is accepted by the tribunal, only then they can prefer an appeal under section 37. The rest of it may not be relevant of section 37. I'll just hand over a few decisions which makes the position very clear.
You're respondent number 1.
I'm number 1, my lord.
Yes.
You know, the first decision is Deep Industries versus ONGC. My lord, in this also, a section 16 was decided, was rejected. Thereafter, the party had moved a section 17 application for interim relief, which was rejected. My lord, against that, an appeal was filed under section 37, and thereafter a CRP was filed. So, my lord, it is not a direct CRP against the rejection of section 16, but my lord, there are some observations made in this which are relevant for our purpose and have been subsequently relied upon by the Supreme Court as well as by the High Court. Now, my lord, may kindly have paragraph 22 for a moment at page 13 of my compilation.
Yes.
One other feature of this case is of some importance. As stated herein above, on 9th May 2018, a section 16 application has been dismissed by the learned arbitrator in which substantially the same contention which found favor with the High Court was taken up. The drill, this is important, the drill of section 16 of the Act is that where a section 16 application is dismissed, no appeal is provided, and the challenge to section 16 application being dismissed must await the passing of a final award, at which stage it may be raised under section 34. What the High Court has done in the present case is to invert the statutory scheme by going into exactly the same matter as was gone into by the arbitrator in the section 16 application, and then decided that the 2-year ban blacklisting was no part of the notice for arbitration issued on so-and-so, a finding which is directly contrary to the finding of the learned arbitrator dismissing the section 16 application. So even a finding in the section 16 application weighed upon the Honorable Supreme Court and said that, my lord, that finding is of significance and that could not have been disturbed. Even in a section 220, article 227 petition, a CRP that was filed against an order that arose from a section 17 order in that case, my lord. So my case stands on a higher footing according to me. For this reason alone, the judgment under appeal needs to be set aside. Even otherwise, as has been correctly pointed out by Mr. Rodgi, the judgment under appeal goes into the merits of the case and states that the action of putting the contractor and his directors on holiday is not a consequence of termination of the agreement. This is wholly incorrect, as it is only because of the termination that the show cause notice dated so and so proposing to impose a 2-year ban was sent. The next sentence is important, Miller. Even otherwise, entering into the general thicket of disputes between the parties does not behove a court exercising jurisdiction under Article 227, where only jurisdictional errors can be corrected. Well, I'll skip the rest of it because it pertains specifically to that case. I will not bother your lordships with that paragraph, but kindly come to paragraph 23. We reiterate the policy of the Act is speedy disposal of arbitration cases. The Arbitration Act is a special, and the Arbitration Act is a special act and a self-contained code dealing with arbitration. This court in Furist de Lawson has specifically held as follows. It is thus to be seen that the Arbitration Act 1940 from its inception and right through to 2004 was held to be a self-contained code. Now, if the Arbitration Act 1940 was held to be a self-contained code on matters pertaining to arbitration, the Arbitration and Conciliation Act 96, which consolidates, amends, and designs the law relating to arbitration to bring it as much as possible in harmony with the institutional model, must be held only to be more so. Once it is held that the Arbitration Act is a self-contained code and exhaustive, then it must also be held using the lucid expression of Justice Tulsapurkar, that it carries with it a negative import that only such acts as are mentioned in the Act are permissible to be done, and acts or things not mentioned therein are not permissible to be done. Then paragraph 24, Mr. Rodgi is also correct in pointing out that the legislative policy qua the general revisional jurisdiction that is contained by the amendments made to section 115 CPC should also be kept in mind when the High Courts dispose of the petitions filed under 227. The legislative policy is that no revision lies if an alternative remedy of appeal is available. Further, even when a revision does lie, it lies only against the final disposal of the entire matter and not against interlocutory orders. So this is to some extent or to a large extent, Millard, an interim order. So this part of the judgment also, Millard, helps me to that extent. So Millard, Millard, in this case, ultimately they interfere with the order of the Honorable High Court under the CRP, and ultimately they direct that the arbitral proceedings may be disposed of as expeditiously as possible at paragraph 25. Now, Millard, the next judgment is Bhaven Construction versus Sardar Sarovar Narmada Nigam. This is, Millard, 2022, volume 1, SCC 75. The Lordship may come to paragraph, I'll just read 2 paragraphs of this, Millard, para 20 and 26. Which your lordships will find at page 25 of the compilation.
Yes.
In the instant case, the respondent number 1 has not been able to show exceptional circumstance or bad faith on the part of the appellant to invoke remedy under 227 of the Constitution. No doubt the ambit of 227 is broad and pervasive. However, the High Court should not have used its inherent power to interject arbitral process at this stage. It is brought to our notice that subsequent to the impugned order of the sole arbitrator, final award was rendered by him on merits, which is challenged by the respondent in a separate section 34 application, which is pending. Now, Millard, paragraph 26, Millard, it must be noted at page 27, it must be noted that section 16 of the Arbitration Act necessarily mandates that the issue of jurisdiction must be dealt first by the tribunal before the court examines the same under section 34. Respondent number 1 is therefore not left remediless and has statutory remedy provided a chance of, has been provided a chance of appeal. In Deep Industries, this court observed as follows. Millard, para 22 is extracted, which I've already read, Millard. In view of the above reasoning, we are of the considered opinion that the High Court erred in utilizing its discretionary power available under Article 226 and 227 of the Constitution. Thus, the appeal is allowed and the impugned order of the High Court is set aside. There shall be no order as to cause. Before we talk, we make it clear that the R1 hearing is at liberty to raise any legally permissible objection regarding the jurisdictional question in the pending 34 proceedings. Millard, 1 Madras High Court, I'll show Millard a decision at page It starts at page 28 of my compilation. If your lordship could kindly come to, it again refers to these decisions. I'll just read the para 30 to 35 are relevant. Again, deep industries is referred to, and Bhavan construction also. Your lordship may just mark the paragraphs 30 to 35. I will not bother reading. Then my lord will come to the Law Commission report, which precisely went into this aspect, whether the remedy of an appeal ought to be deprived or ought to be denied to a party who's aggrieved by the rejection of the Section 16 application. The law
16
co-
2 and
Yes, my lord. So if that remedy, since that remedy is deprived, if the application is rejected, so whether that is actually, that calls for a reconsideration or not, is something that the Law Commission of India in its 176th report looked into, which your lordship will find at page 43. It starts at 43. There's a covering letter, Millard, by the chairman of the Law Commission to the Law Minister at page 44. I'll skip that. Your lordship may come, I'll just read two paragraphs of this, Millard. Page 47. Here, Millard, the foreign law was taken into consideration. The foreign commentaries were also taken into consideration. A very detailed analysis was done. So 47, your lordship will see at the bottom of page 47. In model law, they are referring to the UNCITRAL model of law, Millard. In model law, Article 16 contains only 3 clauses. Clause 1 and 2 thereof correspond to clauses 1 to 4 of Section 16 of the Indian Act of 96. But the model law contains a further clause, subclause 3, which reads as follows and which is absent in Section 16 of the Indian Act of 96. Clause 3 of Article 16 of model law reads as follows to the extent relevant to the present discussion. The arbitral tribunal may rule on a plea referred to in para 2 of this article either as a preliminary question or in award on the merits. If the arbitral tribunal rules as a preliminary question that it has jurisdiction, any party may request within 30 days after after received notice of that ruling, the court specified in Article 6 to decide the matter, which decision shall be subject to no appeal. While such request is pending, the arbitral tribunal may continue the proceedings and make an award. So there is a remedy provided under the UNCITRAL model. Court specified in Article 6 can look into, Millard, challenge preferred against, Millard, rejection of a Section 16 application. In other words, Millard, the second sentence, 16.3, the second sentence, which I read, Millard, if the arbitral tribunal rules as a preliminary question that it has jurisdiction, my lord sees it,
yes.
has jurisdiction, any party may request within 30 days after received notice of that ruling, the court specified in Article 6 to decide the matter, which decision shall be subject to no appeal. While such request is pending, tribunal may continue the arbitral proceedings and make an award. The Indian Act of 96 does not contain a similar provision in Section 16, enabling the arbitrators to decide the above issues as preliminary issues or for an immediate court intervention if the plea is rejected, as in the model law. Under Section 37(2)(a), which I read, Millard, of the Act, an appeal is provided to the court only against an order of the arbitrator accepting the plea referred to in Section 16(2) or 3, but not where said pleas are rejected, though the model law provides an intermediate remedy even in cases where such pleas are rejected. Then they go on to discuss the UNCITRAL model, and they also refer to some other foreign laws also. At page 49, your lordship will see they refer to the German Act, the Zimbabwe Act, the Korean Act, Irish Act, Canadian Act, and the New Zealand Act as well. But I'll skip all that. I'll come to the conclusion, which your lordships will find at page 51 of the compilation. 2.12.5. The question then is as to whether Section 16 is to be amended in view of reliance on the above opinion of leading authors and hardship referred to. After serious deliberation, the Commission has taken the view that if an immediate appeal is provided in 37(2) as under the model law against orders of the arbitral tribunal under section 16. Rejecting an objection as to the tribunal's jurisdiction, the provision is likely to be abused. And even if it is said that the pending an appeal before the court, the arbitral proceedings may go on, it is more likely that the arbitral tribunal may suspend its proceedings during that period in view of the possibility of the abuse. If a right of appeal is provided against interlocutory orders, the commission has decided not to give importance to the weighty arguments in favor of a right of appeal set out above. The remedy is only to make an application for setting aside the award under the award after the award is provided under section 16(6). So they reaffirmed the position, Millard, after looking at various other laws, various other opinions of different authors of international repute, Millard. They confirmed the position that the only
So in an application under 16(6), the agreed party may take plea that the tribunal was not having jurisdiction.
yes, they can.
Later on, they can take
They can
this.
take, yes, Millard. They can take. In fact, that is mentioned here. It is therefore felt not proper to provide for the last paragraph of 51. It is therefore felt not proper to provide for any appeal against an order refusing a plea of want of jurisdiction. Section 16 and 37(2) will remain unamended. But in 34, it is to be clarified by way of an explanation that the applicant, while seeking to set aside the award, can attack the interlocutory order of the arbitral tribunal, rejecting a plea of want of jurisdiction as permitted by 16(6). So they can take that plea, Millard, all these pleas before the 34 court. Now, Millard, that's my submission insofar as 16 is concerned. That, Millard, the only remedy left to them is to approach the, await the outcome in the arbitral proceedings. And there are also issues framed. The issues which they seek to, Millard, raise before this honorable court, Millard, are already issues, Millard, which are framed by the learned arbitrator. That, your lordships. I'll come back to the issues, Millard, but your lordships may also note a recent decision of the Honorable Supreme Court. It's Hindustan Petroleum Corporation versus BCL Secure Premises. So, judgment, Millard, that was delivered on 9th December 2025. This takes forward a discussion in the Cox and Kings judgment, which also dealt with group of companies, Millard, which has been relied upon by the learned arbitrator. But this judgment takes forward the concept of group of companies doctrine and says the referral court can also refer to arbitration a party who is considered to be a veritable party. I'll just read two paragraphs from this, Millard, paragraph 25 and 26.
You'll be giving a copy of that judgment.
Millard?
You'll be giving a copy of that judgment.
No, it's there in the compilation.
It is in this compilation.
Yes. Page 53.
Yes.
Look, the Cox and Kings decision, which was a constitution bench decision, Millard, considered the group of companies doctrine that is extracted at paragraph 24 at page 62. I will not bother reading this, Millard. Your lordships may refer to 25, para 25 and 26.
Yes.
A careful reading of the above passage reveals that the referral court should be prima facie satisfied that there exists an arbitration agreement and as to whether the non-signatory is a veritable party. It further holds that even if the referral court prima facie arrives at the satisfaction that the non-signatory is a veritable
What is the
party.
meaning? Non-signatory is a veritable party.
Millard, it means it actually the veritable party is discussed in the next paragraph also, Millard. This will clarify, Millard, my lord's question.
Yes.
It further holds that even if the referral court prima facie arrives at the satisfaction that the non-signatory is a veritable party, the arbitral tribunal is not denuded of its jurisdiction to decide whether the non-signatory is indeed a party to the arbitration agreement on the basis of factual evidence and application of legal doctrine. The court further reinforces this proposition by holding that as to whether the non-signatory is bound would be for the arbitral tribunal to decide, which the arbitral tribunal in our case has already decided, Millard, while rejecting the 16. But what is primordial is that it should be demonstrated prima facie before the referral court that the non-signatory is a veritable party. According to the Illustrated Oxford Dictionary, revised edition so-and-so, the word veritable means real, rightly so-called, a veritable feast. In substance, it means truly, genuinely, for all intended purposes. The referral court under section 11 is not deprived of its jurisdiction from examining whether the non-signatory is in the real sense a party to the arbitration agreement. So this is what is important. In the real sense, whether they are a party to the arbitration agreement. The answer thereof will depend on the facts and circumstances of each case after examining the documents pertaining thereto. Well, I am referring to this only because the group of companies doctrine is not the last word on the subject. And HPCL, this particular judgment says that you can also look at whether they are a veritable party or not. Now, as I said at the outset, Millard, the whole dispute is that funds from the partnership firm were, Millard, unlawfully misappropriated and then parked and diverted to the companies. And thereafter, a lot of other illegalities also happened, including dilution of shareholding in the companies, Millard. So, Millard, all those make them a very, very veritable party, if I may say so, Millard. So, therefore, they cannot be, Millard, now at this stage, and that too by way of a CRP, Millard, a civil revision petition under 227, be, Millard, knocked out of the arbitration proceedings, particularly when they were conscious, when they were aware, they were served in the Supreme Court, and they were parties there all along, and they never objected. They never filed a review before the Supreme Court, challenging the order by which the Supreme Court had referred the dispute, the entire dispute, Millard, to a very reputed honorable judge of this honorable High Court, Millard. So therefore, I am saying, Millard, that the order certainly, this order under section 16 certainly doesn't call for any interference. And also one more aspect which I point out, Millard, this, of course, might be going into the domain of merits a bit, but Millard, I will just point out the CRP, as I said, is supported by an affidavit at page 19, Millard.
Yes.
And these are the companies, Millard, the companies which have filed the revision petition. Your Lordship will see that it's supported by an affidavit at page 19. I, Preeta Bezborua, agent so-and-so, wife of Prabhat Kamal Bezborua, so-and-so, do hereby solemnly affirm. Now, Millard, Prabhat Kamal Bezborua, your Lordship will find at page 3 of the CRP in the memo of parties.
Right.
Yes, Millard. Number 4, Millard.
Number.
So my whole case before the arbitration proceeding is to a large extent, Millard, on the collusion and the hand-in-glove manner in which parties acted, and not just parties, Millard, even some of the chartered accountants acted. So that dispute is pending. And as I pointed out, Millard, there are issues also framed by the learned arbitrator, which will go into these aspects in more detail once the final award is passed. So, Millard, escaping or avoiding those proceedings only shows, Millard, that they want to avoid a trial on the issues. Because if your Lordship will recall, that's what the other partners had done, the other parties, individuals had done when they filed the Section 8. They wanted to avoid the suit there. Now, Millard, the suit, Section 8 was rejected. That was affirmed in the CRP. But after noticing all the findings, the Supreme Court said, no, you go and decide it before an arbitrator. Now, Millard, now they are coming and taking another stand that the arbitration proceedings are not maintainable because we are not parties. They could have taken the stand before.
So your main case is under section 16, 2, 5, and 6.
2, 5, and 6. And that, Millard, the Arbitration Act is a complete code by itself. It's a self-sufficient code. And any interference by way in a Article 227 petition, Millard, would invert the scheme of the Act, as Millard was held by the Honorable Supreme Court in Deep Industries decision. You know, just one more decision on section 16. I'll just hand over. My lords might have come across this decision. It's a 7 judges bench, my lord, of the Supreme Court, where the issues pertain to, my lord, whether an inadequately stamped agreement can be looked into by a section 11 court or a section 8 court while referring to the parties to arbitration. Look, my lord, I'll just point out one paragraph which is of some importance. And which is, my
Please
lord,
tell me the name of the party.
this was a reference to a larger bench. So it's called in re, it's interplay between arbitration agreements under Arbitration and Conciliation Act. I'll give the citation, sir, to your junior. I'll give the citation.
I have to reply today.
Yes.
Anyway.
2024 6 SCC 1.
The citation is 2024 6 SCC, page 1. Now, my lord, may just see. I had the occasion to appear in this matter. I'll just provide the relevant para, which is at 131, my lord, page 131. Section 16 empowers the arbitral tribunal to rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of arbitration agreement. Importantly, the parties have a right under sections 16.2 and 16.3 to challenge the jurisdiction.
Which para you are reading?
Para 131, my lord. This is at page 76 of the SCC.
Yes.
Para 131. Section 16, it starts with section 16.
Yes.
Section 16 empowers the arbitral tribunal to rule on its own jurisdiction, including ruling on any objection with respect to the existence or validity of arbitration agreement. Importantly, the parties have a right under section 16.2 and 3 to challenge the jurisdiction of the arbitral tribunal on grounds such as non-existence or invalidity of the arbitration agreement. The arbitral tribunal is obligated to decide on the challenge to its jurisdiction, and where it rejects the challenge, it can proceed with the arbitral proceedings and make an arbitral award. It is the principle of procedural competence which recognizes the power of an arbitral tribunal to hear and decide challenges to its jurisdiction. Once the arbitral tribunal makes an arbitral award, section 16.6 allows the aggrieved party to make an application for setting aside the award under 34. Section 16.5 and 16.6 further show that Parliament has completely ousted the jurisdiction of the courts, my lord, has completely ousted the jurisdiction of the courts to interfere during the arbitral proceedings. Courts can intervene only after the tribunal has made an award. Thus, section 16 is intended to give full effect to the procedural and substantive aspects of doctrine of competence. That's all, subject to my learned senior submissions.
We'll continue at 2.
My lord.
You have to explain what is this doctrine of competence?
Lord,
At 2.
It's well emanate from Germany and France. It means competence in the their language.
At 2, you have to explain. Sorry, a meeting was going on, so I got late. Yes.
Just to respond to your lordship's query on doctrine of competence, this is discussed under a heading in the 7 judges decision which I shared, my lord.
No, you just give me an idea. What is it?
It basically means the jurisdiction or the power or the competence of the tribunal to rule on its own jurisdiction. So that is something which is sacrosanct, my lord, and that is in some jurisdictions, my lord, there are such decisions are subject to judicial review, but in some jurisdictions it's not. And one of the reasons why this is also considered to be very important, this particular power, the competence principle, is to insulate, if I may use the word, my lord, insulate the arbitration agreement. Because the arbitration agreement, as your lordships are aware, is an independent agreement. It's separate. It survives the contract. So therefore, to rule on its own jurisdiction insofar as the arbitration agreement is concerned, being a creature of the contract, it is always competent, my lord, to decide on its own jurisdiction. So just these 2 paras, paragraph 123 and 124, are illustrative on this issue of the same decision. para 123 and 124. And in fact, I'm glad your lordship put me this query on competence, because this also shows that the issues which the learned arbitrator had framed, particularly the issues, my lord, are at page 307 of the record, the CRP. My lord, issue number C,
Issue what is it?
issue number C, D, it starts at page 307. I'm referring to 309, my lord. These are the issues that were framed by the learned arbitrator. Issue number C, D, and I particularly. Issue number C is whether the arbitration proceedings against the respondent number 5 to 15 is maintainable, they being non-signatories and not party to the partnership deed. D, whether arbitration clause in clause 5 of the partnership deed is valid and binding, and disputes raised by the claimant fall within its scope as against respondent number 5, 6, 7, 8, and 9. And I, at page 310, whether the claims of oppression, mismanagement against respondent number 5, 6, and 7 are beyond the scope of arbitration, and whether such claim lie exclusively before the statutory forums under the Companies Act 2013. So these are issues which the tribunal is already seized of. They have been formulated. And in the award, these issues will be addressed one way or the other. So they will have the remedy, my lord, of challenging this under 34 in any case. So, my lord, competence is relevant here, and also party autonomy is also extremely relevant here.
Okay. Yes,
So-
Mr. Mishra.
And a few things which I'll state on the facts, and then I'll go to the question of law, which arises here for your lordships to decide. My lord, the first thing which my learned friend has argued, that he is the sole surviving partner in the partnership deed, no others. So sole survivor, if there is only one partner, there is no question of having a partnership form. My lord, I'll take your lordships to clause 3 of the partnership agreement deed, my lord, at page 34. Your lordship will get it, page 34. I'm sorry, my lord, this should have been typed, but it is not typed. I don't know how it was typed. I'll read it out. Relevant is clause 3 at page 37, man. 37. Fourth line, my lord, from the top, that the partnership deed shall be at will and shall not be dissolved by the death of a partner, and on death of partner, the legal heirs of the deceased partner shall be taken in as a partner in place of the deceased partner. So there is no question of partnership that he is the lone surviving partner. They are partners, my lord. Now, but one more thing which I want to point out to your lordship is the stand of the respondent number 1 before the trial court, where he had filed title suit 38 of 2012, was that he has filed the suit since the petitioner in this petition are not signatories, and therefore we cannot be made, my lord, subject of arbitration. My lord may kindly see the stand which was recorded by the learned trial judge at page, it starts from page 69, but your lordship will get relevant page is 73. 73.
Yes.
My lord, 7th line from the bottom, if your lordship will see, and please. The plaintiff has further submitted, if your lordship got it.
Yes.
Submitted that section 8 of the Arbitration and Conciliation Act 1996 cannot be invoked by the defendant number 4 and other defendants, as we were defendant number 4, 5, and 6 there. As Honorable Apex Court has clearly held that there are a number of defendants and some of the defendants are not party to the agreement, then Section 8 application cannot be applied to a proceeding before the court. This was their stand. And the same stand was there before this honorable court by the High Court in CRP, my lord, which your lordship will find at page, your lordship's judgment starts at page 82. Page 82.
Yes.
Paragraph 3, few lines I'll refer, where their stand is reflected by the court, my lord. Your lordship will see from 8 lines from the top, the plaintiff respondent at page 85.
Yes.
The plaintiff respondent number 1 submitted his written objection raising the plea that subject matter of title suit 38 of 2012 is not covered by the alleged arbitration agreement. Can you see, my lord, their stand? And there are many issues which are beyond arbitration agreement. Moreover, the jurisdiction under Section 8 of the Arbitration and Conciliation Act 1996 cannot be invoked by the court below, as some of the defendants in the suits are not party or parties to the arbitration agreement. And as such, application under Section 8 of the Arbitration and Conciliation Act 1996 is required to be dismissed. So this has been their stand throughout. Then, my lord, since the CRP was, my lord, dismissed by your lordships by order dated 1st of November 2021, the respondent number 5 herein, my lord, respondent number 5 filed an SLP before the Supreme Court. I'll have to, my lord, take your lordships twice, but first I'm taking for different purpose. Your lordship will kindly come to page 442. 442, my lord.
442, and that is in the
It was filed 2-3 days back. Affidavit in reply, my lord. This is affidavit in reply filed by petitioner, my lord, by us. Page 442, annexure N.
Yes. Yes, what is this?
My lord, yes. My lord, Kamal Kishore is respondent number 5 here. He is the SLP petitioner. And your lordship will see at page 4, serial number 4, sorry. Serial number 4, my lord.
Yes.
Boca Hola Tea Company Private Limited, he is petitioner number 1. My lord, it is arrayed as pro forma respondent number 4. Your lordship knows the significance of pro forma respondent. Your lordship also go to next page, my lord. 5 is Kasojan T, his petitioner number 2. He is pro forma respondent number 5. And another is Boca Hola, petition number 3, his pro forma respondent number 6. In the SLP.
Yes.
Now, Supreme Court, my lord, Honorable Supreme Court passed a consent order referring the matter to the arbitrator insofar as the parties who are present there. Naturally, those parties who are not present cannot give their consent. And it's an admitted position in paragraph 14 of their affidavit in opposition, which my learned friend has read out to your lordship. I'll take your lordships to Supreme Court order a little later. After the Supreme Court, my lord, referred the matter to the learned arbitrator, the claim petition was filed. claim was filed by the respondent number 1. Now, your lordship will see at page 96, my lord. At page 96,
Yes.
now I just want to show, my lord, that where we are. Now, your lordship will see with the petitioner before your lordship are at serial number 5, Boca-Cola Tea Company. So we are respondent number 5, 6, and 7. This is the claim petition filed before the learned arbitrator.
Yes.
Now, after the claim petition was filed, we filed an application for deletion of our name on the ground that Supreme Court has already referred, and the Supreme Court order confines only to the parties present and who are the partners of the partnership deed, and place Supreme Court order. That application was filed, my lord. My learned friend has taken your lordships to page 312, 318, and 324. This was on 6/5/2025.
Yes.
If your lordship can kindly come to page 313. 313.
Yes.
It is submitted at 313 paragraph 10. It is submitted that continuation of instant arbitration proceeding against the answering respondent number 5, who is not a signatory to arbitration agreement, is beyond the scope of Arbitration and Conciliation Act 1996. The respondent number 5 has never consented to submit to the jurisdiction of the arbitral tribunal. This will be important, my lord, because Supreme Court, my lord, has actually appointed the learned arbitrator on consent of the counsel of the parties present. Nor it can be inferred from the conduct of respondent number 5 that respondent number 5 has ever consented for submitting itself to the jurisdiction of the arbitral tribunal. Now, here only, my lord, I'll take your lordships to paragraph 6, which my learned friend has taken lordship to. Respondent number 5, having some business transaction, that is purchase of green leaf and payment made thereof to respondent number 2, and is not involved in dispute regarding share, interest, control of respondent number 2. Well, we just purchased tea leaves, green tea. And not only from this, my lord, from so many other firms. Now, on that basis, they are trying to make out a case that there was collusion, etc. Now, my lord, the learned arbitrator rejected our petition, and we are before your lordship. And the law is that the general law, my lord, is that those who are non-signatories cannot be made to face an arbitration proceeding. There are exceptions, and the exceptions are carved out in many ways. For the present, we are concerned that if somebody holds that no, we are in with them, we are hand in glove as they are alleged, and therefore applying the doctrine of group of companies, we also should be roped in. That is an exception to the rule.
No, but today we are considering a limited question.
That's
as to
right.
whether the objection raised by you in this civil revision petition can be considered by this court, or you have to wait till passing of the arbitral award by the arbitrator and
No,
then
there is a direct
then-
decision on the point, my lord. Article 226, I'll come directly to that point. Article 226 and 227, your lordships know, is basic structure of the constitution. And nobody, my lord, can say that 227 shall not apply in a particular case or shall apply in or shall apply in a particular case. That nobody can say that. Now, I'll, my lord, please. And that, well, I was trying to tell your lordship that we will fall under exception. The question I would have raised is who has decided this point? Now, your lordship will see 226. I'll come to that. My lord, my lord, there is a case, Punjab Power Corporation, which covers my case, and I'll come to that. But first, I'll want to take your lordships to Section 5 of the Arbitration and Conciliation Act 1996. Section 5, because this is what was referred, and say that no petition under 226 can be entertained. 227 can be entertained. 5 is, by not extent of judicial intervention. Notwithstanding anything contained in any other law for your lordship.
yes.
Notwithstanding anything contained in any other law for the time being in force, in matter governed by this part, no judicial authority shall intervene except where so provided in this part. Now, this was, my lord, pressed in the case, and I'll refer, my lord, one by one. First case, my lord, my learned friend has referred. I'll refer that only. My lord, do I have to say, my lord, refer the case that 226 and 227 is basic structure of the Constitution, and where the arbitrator lacks jurisdiction, it can be challenged under Article 227 without waiting for the award to be passed under Section 34. If that is clear, I proceed further. Otherwise, I will just refer Chandra Kumar case, my lord, just to show that 226 and 227 is the forms basic structure of the constitutions. I'll place, my lord, 1997 3 SCC.
Oh, that is the question to be decided today. Whether
Yes.
because of the bar of section 16 subclause 5 and section 16
My lord, the
6.
statutory provision cannot bar the provisions, my lord. I'll just take your options through that. I'll take deep industry. Section. My lord, kindly come to 2020. My learned friend has just cited Deep Industry Limited, 2020 15 SCC 706. Here, Section 5 was placed into service. 2020 15 SCC 706. Your lordship will come to paragraph 17 at page 714.
Yes.
This being the case, there is no doubt whatsoever that if petition were to be filed under Article 226, 227 of the Constitution against the order passed in appeal under Section 37, the entire arbitral process would be derailed and would not come to fruition for many years. At the same time, we cannot forget, this is important, my lord, at the same time, we cannot forget that Article 226 is a constitutional provision which remains untouched by the non-obstante clause in Section 5 of the Act, which I have just placed. In these circumstances, what is important to note is that though petition can be filed under 226 against judgment allowing or dismissing first appeal under Section 37 of the Act, yet the High Court would be extremely circumspect in interfering with the same, taking into account the statutory policy as adumbrated by us herein above, so that interference is restricted to orders that are passed which are patently lacking inherent jurisdiction. Now, the same bench, my lord, had presided over by Justice Nariman, 3 judges bench.
Yes.
My lord, the next case that I'll place before your lordship is Punjab State Power Corporation versus Emta Coal Limited. 2020 17 SCC, page 93.
Tara?
Yes. My lord, paragraph 4. Paragraph 4. We are of the view that a foray of writ court from Section 16 application being dismissed by the arbitrator can only be if order passed is so perverse, this is our case, is so perverse that the only possible conclusion is that there is a patent lack in inherent jurisdiction. A patent lack of inherent jurisdiction requires no argument whatsoever. It must be the perversity of the order that must stare one in the face. Now, I'll show my lord the perversity. The perversity that has occurred in the impugned order passed by the learned arbitrator.
Yes.
My lord, kindly come to page 20. The relevant will be, my lord, at page 28, paragraph 16. Paragraph 16.
Yes.
Law relating to the application of doctrine of group of companies is therefore no longer res integra. There cannot be two opinions that a non-signatory company can be impeded to single composite arbitration by invoking the group of companies doctrine or on certain circumstances. It is always not necessary that a company for being impeded in arbitration proceeding has to be a signatory to an arbitration agreement between the claimant or other respondent in such arbitration proceedings. So if a doctrine of group of company is invoked, even non-signatories can come in. Then my lord, second part is, as discussed above, the respondent number 5, 6, and 7, that is we, my lord, the petitioner, did not contest the plea taken by Kishore Kamal Bej Barua, respondent number 4, in the SLP filed before the Honorable Supreme Court for invoking doctrine of group of companies. So the learned arbitrator, with all respect, my lord, in order to rope us in, goes to the SLP, what is mentioned in the SLP. By the aforesaid order passed by the Honorable Supreme Court, it was not left to the arbitrator to decide whether non-signatory is bound by the arbitration agreement. Now, whether Supreme Court decided that these petitioners who were pro forma respondent in SLP are bound because of invoking doctrine of group of companies. So therefore, I was saying, my lord, the question that will arise for your lordships to decide the maintainability will be this: whether Supreme Court has gone into, or it's in order passed on consent. I'll take your lordships now to the Supreme Court. 1991. Supreme Court order. Paragraph 7 and 8 are relevant. These are the two paragraphs, my lord. Page 91, my lord, is the Supreme Court order.
92.
Relevant is at 92, paragraph 7 and 8. Both sides seeks appointment of sole arbitrator in terms of clause 5 of the partnership deed dated 16/11/1976, executed between parties, which reads as follows: Sri R.K. Bej Barua and N.K. Bej Barua, two of the partners, shall jointly manage the financial affair and bank accounts of the firm. Any dispute or difference, unless otherwise agreed, shall be referred to other partners in the first instance. There are two things: partners in the first instance, other partners, and if not resolved, shall be referred to the arbitrator of mutually agreed third party. So there has to be a mutual agreement for appointment of the arbitrator. Now, your lordship will see 9, only 2 lines, paragraph 9. We accordingly, with the consent of the learned counsel for the rival parties, so basically, the order of the Supreme Court, my lord, is an order which is passed on consent. Supreme Court did not go into the doctrine of group of companies to hold that we should be also made party in the arbitration proceedings. Supreme Court did not decide this. And then what the learned arbitrator has said, the second part, now, your lordship will kindly come to, I'm sorry, I'm bothering your lordship, kindly come to page 29, my lord.
Yes.
I've placed Supreme Court order now, I'll show, my lord. Page 29.
Yes.
By the aforesaid order passed by the Honorable Supreme Court, it was not left to arbitrator tribunal to decide whether non-signatory is bound by the agreement. So learned arbitrator, in fact, did not decide anything. He said Supreme Court has already decided, which is on the face of it perverse. Just read the order of the Supreme Court, whether it is based on doctrine of a group of companies. If it is not, the order is perverse. And my lord, kindly, I'll take your lordships now again to the SLP. My lord, SLP, at page 442 of the affidavit in reply filed by us, my lord. On 5/1, we filed this reply. 442, I have just taken your lordships through.
Yes.
My lord, the learned arbitrator, my lord, looked into ground F, G, and H of the SLP at page 452. 452. These are group of companies. I don't know why, but it was mentioned in the, my lord, SLP, wherein, my lord, Chloro Control India Private Limited was referred and quoted, paragraph 17, which deals with group of companies at page 453. Then your lordship will come to 454.
Yes.
Here, my lord, for invoking group of companies, Mahanagar Telephone Nigam versus Canara Bank was referred and quoted in detail. Then your lordship will come to 547. 457. For that, Honorable Court also noted that group of companies doctrine has now applied to domestic arbitration, so and so. So again on group of, now what that arbitrator says is that we have not opposed this. We are not opposed. And therefore, we are bound. But Supreme Court has not even referred. And furthermore, your lordship will kindly see ground number B, C, and D. This petitioner in the same breath, what he says at page 450. 450, madam. Yes. 450. Ground B. The Honorable High Court has failed to appreciate the error of learned court below, which ought to have taken note that defendant number 6 to 12, we are included here. In the title suit of respondent number 1 herein were not necessary parties. And as the suit was for accounts of partnership form, then B, then C, your lordship will see. C also similar. For that, the Honorable High Court overlooked the fact that various applications were filed by defendants 6 to 12 in title suits for striking out their name below the before the court below. If the court below had allowed the striking out name of defendant 6 to 12, then the dispute would have remained amongst the legal representative of the party to an agreement. Then D, my lord. For that, the Honorable High Court, while impugned judgment, has rightly opined that defendants are necessary parties to the original plaint, and therefore arbitration cannot be the dispute redressal mechanism, therefore rendered pending application for deletion of name infructuous. So what he writes, we have not, we were pro forma respondent, we have not gone, and we have not contested. And my lord, this is an admitted position that we were not before the Supreme Court. And this I will show, my lord, from their affidavit in opposition, which my lord will find at 397, my lord. It was filed on recently, my lord. Paragraph 14, my lord. Page 402, paragraph 14.
Yes.
I'll place the whole paragraph, my lord.
What you want to emphasize by showing this?
I'm
that-
emphasized on two things. First, I will come to that. That it is an admitted position that the Supreme or the order of the Supreme Court was passed on the basis of consent of the parties present. That
Yes.
your lordship will find. Kindly see one, 6th line from the bottom of paragraph 14. This is the stand of the respondent number 1. Your lordship, my lord, it is respectfully submitted.
No, suppose in a case,
Yes,
no notice is served on you and you choose not to appear.
yes.
And in such a case, a consent decree was passed on the basis of the parties which were present before the court. Then whether it is binding on the party on which notice was issued, served,
No,
and who
no, with
choose
respect,
not to
no.
appear.
No, with respect, no. My lord,
Why?
your
Why?
lordship knows about order 12 rule 6. 12 rule 6, several parties are there. Few of them make an admission.
Yes.
Now, if your lordship will see 12(6), where admission of fact has been made either in the pleading, your lordship, or otherwise, whether orally or in writing, the court may at any stage, either on the application by any party or of its own motion and without waiting for determination of any other question between the parties, make such order or give such judgment as it may think having regard to this. Then your lordship will come to 15, order 15, rule 2. Order 15, rule 2.
Yes.
There are more defendants than one. Where there are more defendants than one, and any of the defendant is not at issue with the plaintiff on any question of law or fact, the court may at once pronounce judgment or for or against such defendant. The suit shall proceed only against the other defendant. So I am not present there. The Supreme Court could have decided that I will be covered by the doctrine of group of companies. The Supreme Court could have, but Supreme Court did not go into that. And therefore, your lordship, kindly bear with me just 4 or 5 lines if your lordship can go through. I'll take your lordship through. 6th line at page 402 I was reading. It is respectfully submitted. And interestingly, my lord, there is a case, Hoka Konyak, where similar thing has happened, where question of order 6 and 15(2)k. I have given these, my learned junior will give, my lord. This is by a bench consisting of, Justice Gogoi and Justice Katoki. From Manupatra, I have given Hoka Konyak. Paragraph 10, your lordship will come, just the last para.
Yes.
In the instant case, learned trial court passed decree on 25/5/1994 on the basis of admission made by principal debtor, who were defendant number 1, 3, and 4 in the suit in their written statement. The present petitioner, who was defendant number 2 in the suit, however, did not file any written statement. Since 3 defendants out of 4 in the suit did not have any dispute on any question of fact or law, the court had the option to proceed against the present petitioner under Order 15 Rule 2, because Hoka-Konyak did not agree, did not admit civil, which has not been done. That being the position, non-filing of the written statement by the present petitioner would not amount to admission so as to pass a decree under Order 12 Rule 6 of the Code of Civil Procedure, and so as to bind such defendants by decree passed on admission as against other defendants. Then others. So now, my lord, let me place this few lines, my lord. Page 402,
Yes, para.
paragraph 14, 6th line from the bottom.
It is
It is respectfully submitted that this honorable court may not revisit the order passed by the Supreme Court. There is no question of revisiting. After perusing the records of the court, particularly when such order was based on consent of the present parties. Your lordship kindly marked. Consent of all parties present. And then further, more important, such order ought not to be reconsidered at the instance of party who were served SLP but consciously chose not to appear and object to the dispute being referred to the arbitrator. And I am not there. Where is the question of my consent? And this is not an order on merit by considering the doctrine of group of companies. Now, this is also reflected, my lord, in the impugned order passed by the learned arbitrator at page 25. The order is at 20, paragraph 8 at page 25.
Yes.
Paragraph 8, just top 3 lines I'll read. The present respondent number 5, 6, and 7, though made parties in the said proceeding before the Honorable Supreme Court, were served, they did not contest the same. We neither appeared nor contest, that is an admitted position. Now, my lord, two very important decisions on doctrine of group of companies. It is not just a formality that somebody writes in SLP and then the other party do not consent or contest. Therefore, doctrine of companies shall apply and the case will be disposed of on that. It is not that. It is not a mere formality. My lord, our first decision I'll cite is Cox and Kings, my lord. That is 2024 4 SCC, page 1.
No, whether impugned order was passed on the basis of doctrine of group of company.
No, the
Or
Supreme Court
on the
did not
basis
go
of-
into, but this is what the arbitrator has roped us because of that it was mentioned in SLP and we did not contest. Your lordship will see paragraph 16. That's what he says.
No, your submission, to my understanding, is twofold.
My
That if the impugn order is perverse on
My
the,
lord.
on the ground that though Supreme Court did not specifically mention that the arbitration may be in respect of those absentee parties also, the impugn order says that it is because Supreme Court directed your prayer was rejected.
No, how can that be presumed? I have not appeared before Supreme Court. There is no prayer before Supreme Court. I was not the SLP petitioner, and my lord, I'll make it clear. My stand is the Supreme Court order is based on consent of the parties. My lord, paragraph 7 starts with that. So it is based on the consent
No.
of the parties.
Before this, let me put a query.
My lord.
The contention of the respondent number 1 is that because
Yes.
of bar in 16.5 and 16.6 of the Arbitration Act,
Yes.
this CRP is not maintainable. Your plea is that if there is a ground of perversity, lack of jurisdiction, then in spite of that bar, an application under 227 is maintainable.
And I'm
That is
supported
your-
by Punjab case, Punjab Power Corporation, which I have read to your lordship.
So.
It's
if you want-
entirely covered by Punjab Power Corporation. Punjab Power Corporation says that in a small judgment, paragraph 4, the lordship has read it.
So at this stage, you have to show that apparently or prima facie, the impugn order appears to be perverse.
Yes, it is, because my lord, what the learned, one my lord, learned arbitrator did not decide any question. Learned arbitrator says there is nothing for me to decide in paragraph 16. That is not
Yes.
that
As the
lordship
apex court,
has now at paragraph 16. Yes. And the fourth line, my lord, from the page 29. Page 29. Let's dissect it into two parts. One says,
just a minute. Yes.
page 29, there are two parts, my lord. One is the first line itself, after full stop, as discussed above. Respondents 5, 6, and 7 did not contest the plea taken by Kishore Kamal Bej Barua, respondent number 4, in the SLP filed before the Supreme Court for invoking doctrine of good group of companies, because unless this doctrine is invoked, cannot be roped in. For that, I will show my lord Cox and Kings and ONGC, two cases.
Yes.
I cannot be roped in. And this is first. Second, the learned arbitrator says, by the aforesaid order passed by the Honorable Supreme Court, it was not left to the arbitral tribunal to decide whether non-signatory is bound by the arbitration agreement. So he did not decide anything. It's not that he has decided. He has not decided. A Supreme Court has passed order on consent of the parties who are present. Admittedly, I was not present. So this order is not, in any case, will might not rope me in. And now my learned friend shows that there are issues have been framed. He has already said that Supreme Court has not left anything. So what issue? At page 309, my learned friend has shown the issues. The decision is already there.
No, but on what count the impugn order can be regarded as perverse?
Because the arbitrator, my lord, he had option. If he has seen that Supreme Court judgment is based on consent of the parties. It is not based on doctrine of group of companies. In fact, there is not even a whisper of group of companies. Your Lordship has read the order. Then the arbitrator could have himself decided. It's not that he cannot decide, but he also did not decide that. And then he says, because SLP we have not, my lord, contested, and therefore we are bound by that Supreme Court order. That is perverse. That's what I'm saying. Because Supreme Court did not invoke the doctrine of group of companies.
Okay.
Now, two more decisions I'll quickly place, my lord, and then I'll end up. I know, my lord, your lordship to get up some references there. References there.
You have 10 minutes more.
Okay, I'll finish within that. My lord, I'll first place Cox and Kings, a small judgment. 2024, 4 SCC, page 1.
Yes. Para?
My lord, para 170, 170.5 and 0.8 at page 91.
Yes.
So I'll first place 170.5. The underlying basis for application of group of companies doctrine rests on maintaining a corporate separateness of the group companies while determining the common intention of the parties to bind the non-signatories party to the agreement, arbitration agreement. Then 107.8, to apply the group of companies doctrine, the courts or the tribunals, as the case may be, have to consider all the cumulative factors laid down in discovery enterprises. Resultantly, the principle of single economic unit cannot be the sole basis for invoking group of companies. It's not, my lord, as if we have not opposed, therefore it stands allowed. It requires, my lord, certain formulations. The facts have to be mentioned, and then it has to be stated that yes, we are from, we come within the doctrine of group of companies.
And your submission is that this aspect was not discussed by the.
My lord, nothing was discussed. I'm just asking a question to myself whether our learned arbitrator decided anything, except saying that Supreme Court has referred the matter, and
Therefore, it
in
is
the
binding.
SLP, these grounds were taken. We did not contest, therefore we are bound.
Okay.
Supreme Court has decided. That is, my lord, perverse. And on the face of it, just by reading, Supreme Court did not go into the group of company.
Any other thing?
Yes, my lord. The other decision is ONGC versus Discovery Enterprises, which I have just read out, my lord. That was in Cox and King. That the principle has to be discussed. If your lordship remember the Cox and Kings,
Yes.
I just read it, my lord. 170.8.
Yes.
Your lordship can read together.
Yes. Yes, to apply the group of company doctrine.
Yes, to apply group of companies doctrine, the court or the tribunals, as the case may be, have to consider all cumulative factors laid down in Discovery Enterprises. I'll place Discovery Enterprises. What are the things, my lord?
Okay. Which para? Discovery?
Paragraph 40. Just, my lord, they have given that these are the requirements. 40 at page 75.
Yes.
In deciding whether a company within a group of companies which is non-signatory to arbitration agreement will nonetheless be bound by it, the law considers the following factors: mutual intent of the parties, relationship of non-signatory to a party which is signatory to the agreement, the commonality of the subject matter, the composite nature of the transactions, and the performance of the contract. All these have to be considered, my lord. It is not a mere formality, or it's not available for mere asking that, yes, these doctrine of group of companies would apply here.
And this was
And
not-
then, my lord, and then the last one, which your lordship come to face every day. Every day, your lordship face this. My lord, in a petition, the party, my lord, takes 100 grounds, several grounds. But the court, my lord, refers only the grounds which is placed before it. Therefore, it cannot be said that in my petition I have taken this ground and the court has not considered. On that, my lord, one decision, this will be the last. Wow. Oh, very bad. Yeah. This is Muhammad Akram Ansari, 2008, 2 SCC, page 95. Paragraph 13 and 14, of course, this is an election application petition. 13 at page 98.
Yes.
The appellant submitted that he had taken a large number of points in his election petition, but they have wrongly not been discussed in the impugned judgment. 14. In this connection, we would like to say that there is a presumption in law that a judge deal with all points which have been pressed before it. It often happens that in a petition or appeal, several points are taken in the memorandum of petition or appeal, but at the time of argument, only some of the points are pressed. Naturally, a judge will deal only with the points which are pressed before him in the argument, and it will be presumed that appellant gave up the other points. Otherwise, you would have dealt with them. If a point is not mentioned in the judgment of a court, the presumption is that point was never pressed before the judgment.
So your
before-
submission is that before Supreme Court in SLP, the
None.
doctrine of group of company was not pressed, though it was mentioned in the SLP. And neither
Yes,
the
and
Apex.
well, that's what I'm saying, because it was passed on consent of the parties.
Okay, okay.
It was passed on consent of the parties. My lord, therefore, my submission would be, I just asked two questions to myself, and I addressed two questions. Whether Supreme Court refers the matter to arbitrator by invoking doctrine of group of companies. That is the first question that I asked myself. If yes, I'll be out.
That is no.
No. Obviously, no, it is on consent.
Because-
Number two, my lord.
Yes, yes.
My lord.
What is number
Number
two?
two, whether learned arbitrator decided the issue independent of Supreme Court. Because he says Supreme Court has not left anything for me to decide in paragraph 16. This is what he says.
Okay.
So therefore, my lord, just because an SLP is filed, and which has, my SLP has two grounds. I'll just repeat myself. Two grounds. One is doctrine of group of companies. The other is our name should be deleted. Those grounds B, C, D. So you take into consideration all. Why only that? Because if, my lord, the learned arbitrator had not referred to SLP, perhaps he would not have passed this order. This much, my lord, I'm grateful your lordship has given me patient hearing.
Say anything, 2 minutes.
Just 1 minute.
Yes.
Milord, first is the point that they should have been deleted from the array of parties. That was a ground taken in the SLP, Milord. So the Supreme Court, with all respect, was conscious that that was a ground being taken by Kishore Kamal Bezborua in the SLP. They noticed that ground, and then thereafter they passed the order, send the parties to arbitration. And that order of the Supreme Court, my lord, may note the date, was passed on 21st of November 2024. At page 93 is the date, my lord. 91 to 93 is the order. 21st of November 2024 is when the Supreme Court passed the order. There is no explanation whatsoever, my lord, from the petitioners what restrained them from voicing their objection. They were served. I produced, my lord, the office reports. They were served, but nevertheless, they did not even object even once, my lord, to arbitration. They had the remedy of review, which they never availed. We filed the claim, my lord, SOC, on 7th of March 2025.
Yes.
On 6th of May 2025, my lord, they filed the Order 7 Rule 11, which was treated as a Section 16 application.
Okay.
So they allowed the order to attain finality, and there's nothing in law which prevents, my lord, a pro forma defendant with respect, my lord, from objecting or from filing a review. And as I said at the beginning, my lord, the CRP is supported by an affidavit of the wife of, my lord, one of the parties to the dispute, my lord. So the collusion is writ large here, my lord. That's all.
No, that's not correct. This has not been argued. My lord, Tata Enterprise. Tata Enterprise is a case, my lord, of 7 judges, which says that the companies and its partner, its shareholders and members are different. They are not, they cannot rope in that such and such wife came and therefore it is pollution.
Okay.
In fact,
My lord, this, we'll just pass it on to your lordship. This is Tata Engineering locomotive.
Punjab Power, my respectful submission helps me because the CRP was a revision petition
24.
was by the High Court, which was frowned upon by the Honorable Supreme Court, my lord, and in fact, cost was imposed, exemplary cost was imposed in that case. So I would also respectfully submit, my lord, this is also a fit case, my lord, from provision of cost.
Okay. Heard, Mr. D.
Just 2 lines, paragraph 24, your lordship will see, I'll not bother. The Tata Engineering, I'll give the citation, my lord. It's
Para? I have.
para 24, my lord. Para 24. Para 24, just 2 lines, my lord. The true legal position in regard to the character of a corporation or a company which owes its incorporation to a statutory authority is in no doubt dispute. The corporation law is equal and natural person and legal entity of its own. The entity of the corporation in its entirely separate from its shareholder, it bears its own name, has a seal of its own, its assets are separate and distinct from those of its member. Therefore, my lord, for applying group of doctrine of companies, they will have to lift the veil, the corporate veil. Where was it done? So because Prabhat Barua's wife signed, so we are all colluded. That is not a fair submission.
Heard Mr. D.K. Mishra, learned senior counsel, appearing through video conferencing and assisted by Mr. K. Jain, learned counsel for the petitioner. Also heard Mr. A. Fukan, learned counsel for respondent number 1, as well as Mr. H, who is appearing for me. There was a counsel, Mr. H. Andilya, appearing for this respondent number 3 and 4. You are appearing. Whose name should be reflected? Heard learned counsel for both sides on the question of maintainability raised by respondent number 1, that the present criminal revision petition, civil revision petition is not maintainable in view of the provisions of section 16 within bracket 6 of the Arbitration and Conciliation Act 1996. is it right? 6,
16-6.
16-6. Let this case be fixed for delivery of orders on the question of maintainability on 22nd January.
But there are decisions, I was not listening, that statutory provisions cannot override the constitutional provision. It's a matter of settled law, your lordship knows it. On that, so many decisions are there.
Yes.
Because in so many statutes, they say the order is final. So therefore, it is final, 226 will also not apply.
Now you have to conclude.
I have concluded. Grateful.
Remaining cases would be shown as leftover. Leftover matter.
My lord, after we were.
You may pray before registry. Registry.
Obliged.
My lord, in item number 26, the interim order may be continued.